Yes, now we can start.
Okay. Good afternoon to all participants. So it gives me immense pleasure to introduce our first speaker. So this is the second day of the conclave of IBC. So the first speaker, we have Mr. GP Madan with us, an alumnus from Sri Ram College of Commerce, DU, law graduate from Campus Law Center, and fellow member of ICSI, who holds diploma in labor laws, corporate laws, and management, and has a vast experience of spanning to 36 years in corporate law, secretarial, capital market, financial, and management disciplines. His law firm specializes into corporate legal advisory, arbitration, and litigation at High Court as well as NCLT. He has written various articles on different subjects for professional magazines and web portals. He has addressed more than 1,000 conferences, seminars, webinars, workshops, training programs organized by various professional bodies, industry associations, chambers, ministries, universities. In more than 100 cases under IBC 2016, he has acted as a legal counsel and advisor to many corporate debtors, financial creditors, operational creditors, resolution applicants, resolution professionals, and liquidators. He has also represented many clients in various meetings of Committee of Creditors and Stakeholders Consultation Committee during CIRP and liquidation process respectively. So we are honored and privileged to have you with us.
Yes, sir. You can start your deliberation, sir.
Okay.
Thank you.
Thank you. Thank you, Shivank, for an introduction, and my gratitude to Mr. Sumit Binani and all other office bearers and members of the organizing team of Association of Corporate Advisors and Executives for giving me another opportunity for being amongst you. I feel like it's a homecoming again.
Absolutely, absolutely. The last time you had come, Madan, the feedback was excellent. I think it was 1 year back during the COVID times, and you were again deliberating on a very, topic which was, quite on debate throughout the country. So, welcome once again, Madan. Welcome.
I remember last time it was on the Supreme Court judgment on personal guarantors to corporate debtors. And today, that was a judicial pronouncement by Honorable Supreme Court of India. And today we are going to discuss the disciplinary orders of our own regulator, Insolvency and Bankruptcy Board of India. And I'm really delighted to see the many participants who are also insolvency professionals. Some of them are from Delhi also, I can see from the list. Friends, if I can ask you that you can open your videos if convenient to you. But it should look like that we are, though we are in a webinar, but it should look like that we are in a physical seminar. And we are seeing each other and talking to each other. We are studying, reading the body language also while we are discussing something. That also matters, you know. May I ask if anybody from you right now is facing any disciplinary action or disciplinary proceedings? If you can raise your hand or may write in the chat box. If no, certainly you are with one of the luckiest ones who has not faced these issues so far.
But the threats are always looms.
Pardon?
The threat always looms on each one of us.
Nowadays, it is being said if you have handled any assignment, whether you're handling or have handled any assignment, the DC proceedings, you have to face disciplinary proceedings.
Yes, sir.
That's what the normal general feeling amongst the insolvency professionals nowadays.
Right.
But I think that this fear should go away. This fear should not be there, because I always consider our own regulator, IBBI, as well as the respective IPA, to be our guardian. I always treat them as our parents, that we, the insolvency professionals, are the creation of the law. And the law has also created this regulator to regulate our affairs, to oversee our affairs, to supervise our affairs. And I always consider that when we are a child, and if we commit some mistake, it may be by way of ignorance or maybe by, it may be a deliberate one also. I'll say the bacche to kabhi galti kar dete hai na. But I always expect the parents should always come forward and hold our hand. They should advise us, they should guide us, they may scold us, और कभी जरूरत पड़े तो हल्का सा चांटा लगा दे, कोई बात नहीं. But I never expect the parents to ask their children on commitment of any mistake that please get out of this home for next 2 years or 3 years. Don't show me your face. And I'll ask all your friends also not to entertain you. This is what is happening nowadays in our disciplinary orders. You know, earlier what was happening in the disciplinary orders, whenever the orders were there against the insolvency professionals, the order used to say that Mr. G.P. Madan, I'm giving an example, though I have no disciplinary action against me because I have not handled any assignment while being an IP for more than 5 years now. The order will say that Mr. G.P. Madan, his registration, no, not registration, Mr. G.P. Madan shall not undertake any new assignment for a period of next 1 year from the date of this order. Further, it used to say if any penalty is levied, the penalty shall be levied. Then there will be directions in the order. However, Mr. G.P. Madan shall continue to complete all his existing assignments. So existing assignments were never under any scanner. They were not under any knife. And then the orders used to say this order shall come into effect from the expiry of 30 days from the date of this order. These were the orders before February, March 2022. But now the orders which are there from our own regulator, from our own parent, now the orders say this, the registration number so and so of Mr. G.P. Madan, insolvency professional, is hereby suspended for a period of next 2 years or 3 years, as the case may be. Further, it does not stop here. It says, a copy of this order shall be sent to the committee of creditors of the corporate debtor with respect to which this disciplinary action is being passed, the order is being passed. It does not stop here. Further says, a copy of this order shall be forwarded to all those committee of creditors wherever Mr. G.P. Madan is working as IRP or RP. And then the committee of creditors of all these corporate debtors are at liberty to decide whether to continue with the services of Mr. G.P. Madan or not. And no doubt it is said that this order shall come into effect on the expiry of 30 days from the date of this order. So now the orders are being passed of suspension of registration. This term was not used earlier. Somebody is saying my voice is not clear. Is it so? Is my voice clear or not?
No, it is clear to us.
Okay. And I think Mr.
Maybe
Sunil,
if the person switches off his video, maybe it could be a bandwidth issue at his end.
नहीं, उनका वीडियो पहले ही ऑफ है. Mr. Sunil Jain is writing that his voice is not clear. So now the order says that registration is suspended for a period of 2 years, for a period of 3 years, and the committee of creditors will have to decide now whether to continue with my services or not. Now you see, when my registration is suspended, the word used is suspension. Under this scenario, whether any of the committee of creditors, wherever I'm working as IRP or RP, would they like to continue with me? When they have been given an option, when they've given a discretion, given an opportunity, certainly no COC would like to do that. So ultimately, I'm nowhere in my existing CD where with respect to the action is being taken, and I would not be there in all other CDs also where I'm acting as IRP or RP. And this action of COC, as per the directions of IBC order, it will not be a replacement according to me under section 27 of the code. It's a sort of removal. It's not replacement. Because in case of section 27, the law says if during the course of CIRPs, if COC is of the opinion that the existing resolution professional is required to be replaced. So that's the opinion of the COC. But here in this case, it's not the opinion of the COC because my own regulator has suspended me, has suspended my registration, and now the COC has been given a discretion whether to continue with my services or not. And invariably, what I'm seeing during the last couple of months, the COCs are deciding, are taking a call not to continue with the services of this IRP or RP. So for next 2 to 3 years, now this insolvency professional cannot act in any capacity under IBC. His image is tarnished. His reputation has gone for a toss. His 3 to 4 years, decades of experience, his expertise, his name, his impeccable record with the previous assignment, previous job, or in the practice, there is a big question mark on that. I've seen some of the officials. Mr. Umanatji is asking whether these orders can be challengeable or not. I'll come to this. I'll come to this very shortly, how these orders can be challenged. Now, I've seen some of the bureau and also bureaucrats from the retired bankers or some of the senior officials from the government of India having retired after 60 years of age. Maybe they have served with the government or with the banks for more than 3 decades, 3.5 decades. There is no stigma. There is no black spot. But within 2 years or 3 years of joining this profession, now they are having black spot. That your registration is suspended. You have not confined to the law. You have not acted as per the provisions of the code and provisions of the regulations. And it doesn't end here. If you see the findings in the disciplinary orders, there are questions on your integrity. It is being said that you have acted with malafide intention. Invariably, it is there in every order. Think of this with malafide intention. This is written there in the order. While providing my services to the corporate debtor, while complying with the provisions of the code, there may be some technical error, there may be some technical mistake. And if you hold me liable for that, where from this question of acting with the malafide intent comes forward? This is absolutely not done, not acceptable. Now coming to the provisions of somebody asked that how can these orders can be challenged? You know, as per the provisions of the code, these orders are being passed by a disciplinary committee. Now, this disciplinary committee, as per the code, constitutes of whole-time members. It is written there in law that disciplinary committee shall comprise of whole-time members of Insolvency and Bankruptcy Board of India. The word uses whole-time members. It's not whole-time member. Now, how does this body pass an order? Now, many of our fellow friends would have faced these proceedings. It starts actually with an inspection. This inspection may be suo moto, or this inspection may be on the basis of complaint by anybody. And normally, who are these complainants? Normally, these complainants are either any of the financial creditors or any of the operational creditors or members of the suspended board or by An unsuccessful resolution applicant whose plan has not been passed. These are some of the categories of complainants. Sometimes these complaints are anonymous also. And I'm sorry to say that these anonymous complaints are also being taken care of. There should not be, the cognizance of these anonymous complaints should not be there. And secondly, whenever these complaints are filed, no evidence or proof is submitted along with the complaints. In many of the cases, only bald allegations are leveled against the insolvency professional. And then the moment this complaint comes to IBBI sent this complaint to the concerned insolvency professional and asked him to give a reply within 14 days. And it is rather, please give detailed pair-wise reply to this within 14 days along with all proofs and evidences in support of your reply. Now, who should be asked to give the proofs and evidence? Should it be the complainant or the insolvency professional? Should the complainant be not asked to give proof and evidence in support of his complaint? But unfortunately, that is not being done. And it is the insolvency professional who is asked to give a reply in support of his reply to these bald allegations. Rather, during the course of this entire inspection and investigation post this complaint, the complainant is never invited. There is no cross-examination of the complainant. He simply goes to sleep after filing this complaint. Now, once this complaint is replied to, or sometimes what happens, along with the complaint or on the basis of a complaint, an inspection is carried out. For this inspection, a questionnaire is given to the insolvency professional. He has to submit the details as mentioned in the questionnaire. After receipt of the question, reply to the questionnaire, now an inspection will be carried out, and after the inspection, a draft inspection report shall be shared with the insolvency professional. This draft inspection report will consist of the allegations, or IBBI says observations, of the inspecting team. I say them allegations. Now, these allegations or observations are there in the draft inspection report, and the insolvency professional is asked to give replies to these allegations. So once he submits his reply, after the reply, this inspecting team prepares a final inspection report. And this final inspection report is submitted by this inspecting team to the board. I always raise a question on this also. This inspecting team has been constituted by the board. It means it consists of the board officials only. And then the law says this draft inspection report of the inspecting team shall be given to IP. IP will give a reply, and then the inspecting team will prepare a final inspection report which shall be submitted by the inspecting team to the board. मेरे एक पॉकेट से दूसरी पॉकेट में चीज चलेगी, और I treated the two different entities while both pockets are in my shirt and I'm wearing that shirt. Now, after receipt of this final inspection report, the board now decides whether this matter should go to disciplinary committee or not. And one thing needs to be noted here, that this final inspection report is never shared with the insolvency professional. Principles of natural justice are not followed because IBBI says there is no provision in law of sharing the final inspection report. And actually that's the truth. There's no provision in law. But if there is no provision in law, should the provisions and principles of natural justice be not followed by IBBI? Whenever you go to court and file a complaint or file an application, whether there is provision or not, but the court always gives the other party an opportunity to file a reply, to come before it, to argue the case. But here, because the law lacks something, IBBI does not provide this opportunity of FIR, final inspection report, being shared with the insolvency professional. Now, board decides whether to take any action against the IP or not, whether the matter should be referred to DC or not. So when the matter is referred to DC, a show cause notice is issued to the insolvency professional that these are now the final allegations against you, and this show cause notice, it is written there. This show cause notice is on the basis of the final inspection report, which is not shared. Now, if you're issuing a show cause notice on the basis of a particular document, I do have a right to have a copy of the document, but unfortunately, that's not given. Now, I reply to the show cause notice, and in the reply, I always write that I want to have avail an opportunity of being heard before the disciplinary committee. Now, this entire, all the pleadings along with the show cause notice and my reply, they are referred to the disciplinary committee, and I receive a date of the hearing by the disciplinary committee, from the disciplinary committee. Before the DC, I can appear of my own as IP, or I can appear through my counsel, or I can appear along with my counsel. All these three options are there. Now, during the course of the hearing, nowadays, these are virtual hearings only. Now, what has happened during last 5-6 months, the counsel goes on speaking in favor of the insolvency professional against the allegation leveled in the show cause notice. He substantiates the replies which are given in reply to the show cause notice. He tries to argue in favor of the insolvency professional, but there is no cross question from the disciplinary committee. The disciplinary committee just keeps mum during the hearing. There is no question at all. Is that how the hearings go? My answer is no. Does it mean the disciplinary committee is sitting there with a biased mind, with a predetermined mind? You keep on speaking whatever you want to speak. We have decided what the order is to be passed. Now, once the hearing is over, at the end of the hearing, I always, because I represent many insolvency professionals, I always take this liberty from the DC that whatever I have argued today, I would like to submit it through the written submissions, short written submissions, post-hearing, maybe within next 7 days or 10 days. And DC invariably grants me that opportunity. Then after the DC hearing, I submit that written submission. And after written submissions, maybe within next 10 to 15 days, a disciplinary order comes from the disciplinary committee and is posted, is sent to me immediately, as well as is hosted on the website of IBBI. Now, as I said, what are the contents of the operative part of the order, that suspension and discretion to COC to not to continue with my services. Now, this DC practically is consisting of just one member. Law says the disciplinary committee shall consist of whole-time members. But in reality, this DC consists of one whole-time member. And nowadays, for last 4-5 months, we have 2 DCs. In one DC, we have one whole-time member, and in another DC, we have IBBA chairperson as disciplinary committee. Now, there is a big question mark nowadays whether IBBA chairperson can be called a disciplinary committee or not. I'll come to some of the judicial pronouncement also of last 1 month. Now, once this order is passed, there is no appeal provision in the code. And that is very, very unfortunate. That against the order of the disciplinary committee, we cannot prefer an appeal. Then what is the only option? The only option lies with us is to prefer a writ petition before the High Court under Article 226, 227 of Constitution of India. Now, this writ petition can be preferred before the High Court of Delhi because IBBI registered office is in Delhi, or it can also be preferred before the High Court within jurisdiction of which the registered address of the insolvency professional is there. So now filing a writ petition is the only option. But unfortunately, High Court of Delhi is not giving the stay orders very frequently against the disciplinary mechanism, disciplinary order, not against the disciplinary orders of IBBI, against the disciplinary order which have been passed by other public authorities also. But the difference between IBBI and those public authorities is that in number of those cases in public authorities, there is no one-person disciplinary committee. At least 3 members are there in every disciplinary committee. And in majority of those cases, after the disciplinary committee, there is some appellate authority. And whatever writs are coming before High Court of Delhi, those writs are coming against the order of the appellate authority of the respective organization. But in case of IBBI, we have just no appellate authority and we have just 1 member disciplinary committee. So according to me, the High Court of Delhi, though we have made this prayer number of times, High Court of Delhi should have a lenient view in case of wherever the writ is filed against the orders of the disciplinary committee. Friends, recently you would have gone through the report of the Insolvency Law Committee, which was released in the month of May 2022. Now, in this Insolvency Law Committee, this committee was chaired by Honorable Secretary, Ministry of Corporate Affairs, and IBBI chairperson and IBBI whole-time members were also members of this committee. Now, as per findings of this committee, it accepts the fact that there is no appellate provision against the orders of IBBI or the disciplinary committee of IBBI. It is written there in the report that in many cases, the IPs have to go to High Court or Supreme Court of India and file writ petition. And this is a very, very time-consuming affair. Therefore, there should be some appeal provision against the order of IBBI or its DC. And it has been recommended in that ILC report that Honorable National Company Law Appellate Tribunal, NCLAT, should be the appellate authority against the orders of disciplinary committee. I hope and I wish that this recommendation of ILC is accepted at the earliest and we have some disciplinary mechanism. Friends, slowly and gradually, majority of you are keeping your videos off. At least some of you can keep your videos on. मुझे भी अच्छा लगेगा बात कर रहा हूं मैं आप लोगों से. Thank you so much. Now coming to this appeal provisions, rather writ provisions. During last 1 month or so, in 4 different cases, the writs have been preferred. And fortunately, five writs have been preferred. And out of 5 writs, in 4 writs, there have been orders of stay or suspension of DC order. I'll take these issues one by one wherever these orders have been passed. In one of the cases where the insolvency professional is from the state of Punjab, therefore he preferred a writ petition before High Court of Punjab and Haryana, based at Chandigarh. Amongst other grounds, one of the grounds was that in that very case, the complainant was one public sector bank. I'm not going to name it. Complainant was one public sector bank, and the DC headed by the chairperson, and this chairperson was associated with that bank. Therefore, there is a conflict of interest. This was one of the grounds, but on this ground, the High Court of Punjab and Haryana has granted a suspension order. Suspension of the order. It's not stay. It says the order of the disciplinary committee stands suspended till further order. This is one case. Another case, same, another insolvency professional, again from the state of Punjab, writ petition be preferred before Punjab and Haryana High Court. One of the grounds that chairperson is not a whole-time member. Therefore, chairman cannot constitute disciplinary committee. This is one of the grounds. Now, on this ground, the order has been, this DC order has been suspended. The third case, unfortunately, that case was listed before the vacation bench, and vacation bench normally does not grant such interim reliefs. So there the notice has been issued and matter is now listed in the month of September. Notice has been issued to IBBI. Fourth case, decided day before yesterday, interim order passed day before yesterday by Gujarat High Court. Amongst other grounds, one of the grounds was that law says the disciplinary committee shall consist of whole-time members. But in this case, the disciplinary committee constitutes only one member. It has to be plural. There have to be minimum 2 members. On this ground, the stay has been granted. And in fourth case, the stay has been granted yesterday only by High Court of Delhi. And that's a very interesting case. Actually, out of these 5 cases, in 3 cases, I represented the insolvency professional before the disciplinary committee. The case which has been decided yesterday, not decided, interim order has been passed yesterday. Again, I was representing the IP before the DC. And that's a very interesting case. Amongst other allegations in the show cause notice, one of the allegation was that this insolvency professional who was acting as a resolution professional, post implementation of the plan, he continued to be there as a monitoring professional. He received a particular fixed amount as monthly remuneration. And all these provisions of his appointment and his remuneration were provided there in the resolution plan. And that plan was ultimately approved by Honorable Adjudicating Authority. But now IBBI issues a show cause notice and IBBI says, sorry, this is in violation of Regulation 23A of the Code of Conduct of Insolvency Professionals. You are providing your services to the successful resolution applicant. So according to me, these services are being provided to the corporate debtor post implementation of the plan and not to the successful resolution applicant. Because right now, post passing of the plan, approval of the plan, now the plan is being implemented. Now, who is implementing the plan? There's a big question mark. Whether the plan is being implemented by SRA or plan is being implemented by the corporate debtor. Actually, first of all, this question should have been decided by IBBI. Now, this plan is of the corporate debtor. SRA is an applicant. His plan has been approved. His plan is being implemented, but the plan is with respect to the corporate debtor. So, insolvency professional who is there as a monitoring professional or a part of the monitoring committee is actually providing services to the corporate debtor. And if he is getting some remuneration, why should he not get? If he's devoting his time, he's using his experience and expertise, why should he not get the remuneration? But IBBI says, sorry, no, this was not permitted, this was not allowed. If it was there in the plan, you should have specifically brought this forward before the committee of creditors that this particular provision is there in the plan. If I brought the entire resolution plan before the COC, whether this particular clause is outside the purview of the plan, this is part of the plan. But you say you should have specifically mentioned it before COC, the certain stipulation is there that you shall be appointed as a monitoring professional and you shall be paid such and such remuneration. So IBBI is not, DC is not in conformity with my submissions and DC holds me guilty. There are a number of other allegations also. And for all allegations, DC holds me guilty. Now this RP prefers a writ petition before High Court of Delhi. And on this very ground that this resolution plan has been approved by the Committee of Creditors as well as by NCLT, and the matter went to NCLAT also. NCLAT has also upheld the order of NCLT. Therefore, we do not find any infirmity. For the time being, we need to look into this issue in detail. Therefore, till next date, this order of DC stands stayed. And the next date in the order is now January 2023. Now, these are the 4 orders which have been passed by 4 stay orders or suspension order by various high courts across Delhi, across India. Now, I would like to go through some of the allegations or observations which have been leveled in many cases in the show cause notice and where the IP has been held guilty. And I would like to highlight these cases, these issues, so that we should be very, very careful in future while performing our duties as IRP or RP. In the meantime, Sumitji, if somebody has any question on whatever we have discussed, I will be more than happy to take up those questions. If there is anything in the chat box, please go through, or if anybody wants to ask anything, please.
Yeah,
I think, yeah.
sorry. May I?
Yeah, please.
Badaji, the very interesting last case which you had mentioned, you have mentioned 2 things. One is that the order has been stayed and the next date has been put as January 23. And the copies of the orders would have already been circulated to the COC members and to everywhere. What happens to the fate of this poor fellow, whoever is the person? I don't know. Though the order stands stayed till January 23, but having lost the confidence of having carrying such an adverse order against him, I think it will have a very adverse impact on the impression on the COC members also, though the order is stayed. Don't you feel it's really unfair as far as this IBC, this IRP is concerned?
It is, sir. But what has happened in this very case, this case pertains to a corporate debtor which had 3 different projects across the country, where the CD was having more than 16,000 employees. The company's operations were on the basis of continuous process. It was a continuous process industry. The entire company, all the units were kept in operation during entire CRP period. And during this CRP period, the company earned a handsome net profit of 4,500 crores. And post implementation, now the unit already stands handed over to the successful resolution applicant because the plan has been implemented completely. And at this stage, this show cause notice has been issued. Can you believe it? According to me, this resolution profession should be awarded and rewarded. It should be a case study for other insolvency professionals. But unfortunately, instead of any award or reward, this resolution professional receives a show cause notice and is held guilty.
Sad.
But no doubt about that, whatever you have said, sir, that there is a stigma, there is a black spot. His reputation has gone for a toss. There is no doubt about that. And he will think twice before taking any other assignments, or other applicants will also think 4 times before handing over any assignment to this particular insolvency professional, even though the order stands stayed.
Yeah, so he's already undergoing punishment, in fact.
Yes, sir.
Thank you.
There's one query from Mr. Umanath Pandey that is in the chat box. Mr. Pandey asks queries that don't you think that these type of orders are challengeable in Supreme Court on fundamental rights of livelihood issue and other principles?
Yeah, that's what we are doing. That's what I'm saying, that 226, 227 Constitution of India. At least High Court जाना better रहता है. High Court के बाद एक और opportunity रहती है Supreme Court जाने की, तो it's advisable to go to High Court.
Rajkamal ji can
But
ask this question.
अभी पीछे क्या discussion हुआ है? Let me share the discussion with you. It's an open forum that was also discussed in an open forum. That is why I'm discussing. Number of IPs have decided to file their respective writ petitions before respective high courts, and then they have decided to consolidation of all these writ petitions before the Supreme Court of India, so that these issues can be decided once for all.
Okay.
Particularly on the constitutional validity of the provisions of IBC with respect to disciplinary mechanism. राजकमल जी आप म्यूट पर हैं. You are still on mute. You are on mute. अच्छा, I think ऐसा तो नहीं है सुमित जी आपकी तरफ से म्यूट हो सब?
I was not being allowed to speak.
Okay. Now you are allowed, sir.
There are number of past illustration where IPs, the RP was appointed as a MC also. Monitoring committee, he was supervising. What will happen to those cases? Whether this will apply to those cases or all will be open for disciplinary actions. Though it has been stayed by the Delhi High Court, but still that issue, that limbo is there. Second,
in fact, 99% of the resolution plans wherein monitoring committee have been formed, RPs have been part of the monitoring committee.
Yes.
99% of the resolution plan.
Yes.
Thank you, sir, Raugi, for raising this issue. Actually, according to me, rather I give this advice and I ensured in all my client cases, whether the client is SRA or client is RP, I always insist that there should be a provision in every resolution plan that there shall be a resolution professional of the corporate debtor shall invariably be there in the monitoring committee. I also try to ensure that the resolution professional becomes chairperson of the monitoring committee. Secondly, I also try to ensure that a remuneration of this resolution professional who shall act as either member or chairperson of the MC should be fixed in advance. And also one more thing, invariably post approval of the plan by the adjudicating authority, there are certain objections to this approval plan. There are certain appeals which are filed before the appellate authority. And in all those appeals, RP is always a respondent. Now, if RP is respondent, then why RP should not be there in the monitoring committee? And if RP is respondent, who shall bear the litigation expenses of the RP? So I try to ensure this also, that in every plan, there should be provision that all the litigation expenses with respect to the corporate debtor, wherever the RP is subject to, RP is a party, all litigation expenses shall be borne by the corporate debtor, who shall now be taken over by the successful resolution applicant. So there is no debit to the resolution professional who shall be acting as monitoring committee.
Now, second question is, what the view our parent organizations, suppose I'm a company secretary or a chartered accountant, a cost accountant, or any other institutions, for our spot in our career, our parent organization will take a view, whether they can also take the negative view and take a similar drastic actions.
सर राउगी जी, ये भी आपने बड़ा अच्छा क्वेश्चन रेज किया है, और आजकल ये भी फैशन बन गया है कि आईपी के अगेंस्ट तो आप कंप्लेंट फाइल करते ही हैं, साइमल्टेनियसली एन अपील इज प्रेफर्ड बिफोर द डिसिप्लिनरी कमेटी ऑफ द रेस्पेक्टिव प्रोफेशनल इंस्टीट्यूशन आल्सो. I'm handling some of those cases, and unfortunately the DC of the professional institute says that that is a separate complaint, this is a separate complaint, and we are entitled, we are authorized to take the cognizance of this complaint. I say that there is a separate disciplinary mechanism which has been provided under that Insolvency and Bankruptcy Code. Let there be exclusive disciplinary mechanism under that code, and you cannot take up this issue. But Sometimes these issues are politicized also, you know it very well. And these complaints are unfortunately entertained by the disciplinary committees of the professional institutions. I hope very soon when the Prime Minister Modi's recommendation is accepted in toto, and when this entire disciplinary mechanism will be out of the purview of the respective institutions. I'm waiting for that day. Sorry for me being so blunt and bold. Yeah, Sumit ji, koi aur question usme?
Yeah, GP, I had a small query.
Yeah.
While you were arguing the matter, I think the regulation provides that a resolution professional can continue to provide those services which he was, which he can provide as a resolution professional. Other than those services cannot be provided. So, acting as a part of monitoring committee, basically what he does is that he continues with the going concern operation and continues to have control and custody of the assets till the resolution plan is implemented. So did you not get a chance to place this argument that these are the same services which an IP is supposed to provide, and hence the regulation which prohibits the resolution professional to provide any other services is not applicable? Because these are the same.
Sumit ji, you can go through that particular order which is impugned, which has been challenged before High Court of Delhi, where the order was yesterday. In the order, you will find the observations and our defenses and the findings. Everything you will find there. All these issues were raised before the disciplinary committee. But as I told you, when the DC in majority of the cases is sitting with a biased mind that we need to take this action, we need to take this action.
Okay, and one more thing. Today morning, a resolution professional was asking me that whether he can become a part of the monitoring committee now that there is a stay, but should he accept being a member of the monitoring committee, or should he relinquish that position?
My answer would be he should continue, or he should accept, and whosoever is continuing should continue with that assignment. However, if somebody has to yet to take the assignment, the one should be very clear about the language to be used so that it does not look like a contravention of Regulation 43. And we can always draft that particular language. That's not an issue. But I'm of the view we should invariably be part of the monitoring committee, because without us, the plan cannot be implemented. Otherwise, the SRA will be having the people of his own choice in the MC. I think IBBA should think from this angle. It means you are handing over everything to the SRA without investing the anything. Maybe sometimes they are investing just paying CRP costs and the entire unit is being handed over to them. Should it be allowed? And who knows about this CD so far? It's the RP who knows, because he has been at the helm of affairs for a year or two. He knows each and everything about this corporate debtor. He has to be there.
I agree. This whole thing about the post-implementation of the plan, that is very vague in the whole code. There is no guidance, and it's just developing with practice. And whatever RPs and the COC are doing in good faith, that again is now getting backfired.
Okay, now should I take up the issues, or is there any other question, Sumitji, or should I take up the issues?
No, I think please proceed. We only have 20 minutes, so kindly proceed. Yeah.
Okay. Now, in one of the cases, rather in two of the cases, I'm sorry, I'll not take the names of the corporate debtor and names of the insolvency professional. What has happened in these two cases? Same insolvency professional, but two different corporate debtors. But both are into continuous process industry, both the corporate debtors. Both go into insolvency, CIRP is there, and same IP is appointed as resolution professional in both the cases. Incidentally, in both the cases, show cause notices are issued. One case is decided in the month of March this year, March 2022, and another case is decided in the month of July 2022, current month. Now, allegation, one of the allegations in both the cases is also very common. You know, in case of continuous process industry, there are certain services which are required on continuous basis. Not only services, but certain items also, certain goods also, which are required on continuous basis. And if they are not supplied to the corporate debtor on continuous basis, the unit will come to a halt, unit will come to a standstill, even the unit may close on the very next day. Now, what are these essential items? Number one, no doubt about the wages and salaries of the employees and workers. Other is fuel. It may be oil, it may be gas, it may be coal. And the third issue is of refractories. If there is furnace, certainly you need the repair of the furnace on frequent basis. And for this furnace, you need supply of refractories on continuous basis. And if the refractories are not there, certainly the repair of furnace cannot be there. And for this furnace, there are specific and specialized refractories. And normally these are not available in the market, open market. You go to anybody and buy these. They are tailor-made. और normally आप उसी से खरीदते हो replacement के लिए भी जिससे आपने पहले खरीदी है. And fourth or fifth of these issues is of truck unions. Transport union का case बहुत से मेरे friends handle कर चुके होंगे. They know it very well in a particular state or in city. If there is a truck union, they will never allow any outside truck to enter into their territory. And if the truck union is not happy with you, they will not allow their own members also to lift any material from your factory. अभी से आप कार्टेल कहें या कुछ भी कहें, Competition Commission of India has also tried number of times, but आज तक कुछ बन नहीं पाया on this issue. Now, in all these cases, all these authorities, not authorities but bodies, I'll say, whether fuel supplier, gas supplier, refractory supplier, truck unions, they insisted that unless our previous dues, pre-CIRP commencement, unless our previous dues are paid, we are not going to supply you the material. अब अगर सपोज फ्यूल वाला, गैस वाला, कोल वाला ये बोल देता है कि मैं आपको कल से कोल तब दूंगा अगर मेरे पिछले पैसे मिलेंगे तो दूंगा, नहीं तो नहीं दूंगा, और अगर आपको कोल नहीं मिलता है तो आपकी फर्नेस तो बैठ जाएगी, बंद हो जाएगी. अब आप एज ए इंसॉल्वेंसी प्रोफेशनल आप उसके पास जाते हैं, मनाते हैं, भाई एज पर लॉ यू हैव टू फाइल योर क्लेम फॉर pre-CIRP expenses. You tell him, but he doesn't agree with this. Well, I don't know the law. I want my money. You pay me the money, I'll supply you this. If you don't pay the money, I'll stop supplies. Now, this resolution professional is in a double whammy. एक तरफ law बोलता है he has to keep the company as a going concern. Section 25, I think, to keep the CD as a going concern. And on the other hand, there is the moratorium. Section 14 is there. Now he is in effect whether to comply with Section 14 or Section 25. What should he do? I asked this question day before yesterday also in one of the programs. I asked this question to you also. I would request again some of you to please open your videos. I asked you this question as a resolution professional. What will you prefer? Would you like the CD to run as a going concern? Or would you like to comply with Section 14, will not pay the money to the supplier and will allow the company to shut down on the next day? What would you like to do? I'm raising this question to you. Sumiti shayad unmute karna padega, I think, if somebody wants to speak.
Yeah,
Like, I should continue running the company by paying the dues. I think हम में से majority का या सभी का यही view होगा that you would like the company to run as a going concern, and for this purpose you would like to pay to that entity which is asking for your money rather than blackmailing. But if you pay this money, IBBI says you have not complied with the law, therefore you are held guilty. Now, the similar allegation is there in both these cases of this corporate debtor against one insolvency professional. One matter, as I said, decided in March, another in July. The March order says of the disciplinary committee of the same board, March order says, I am not guilty. We accept your plea. We accept your submission. You have performed your duty to keep the company as a going concern. So we accept your submission. While the July order says, sorry, we do not accept your submission. You should not have paid. You should ask the other party to file the claim only, and you should not have paid money. Now, IBBA forgets that in this case, the liquidation value of the assets of the corporate debtor were 12,000 crores and the plan value was 20,000 crores. It's the same case where the resolution professional has earned a net profit of 4,500 crores. हम सब कुछ भूल जाते हैं और वे कहते हैं कि तूने सेक्शन 14 को कंप्लाई नहीं किया है, इसीलिए you are held guilty and your registration is suspended for a period of 2 years. Should such an action be taken by our own board? Are we being punished for keeping the company as a going concern? What are we? Are we commercial person or not? Are we CEO of the company or not? Or are we simply a compliance officer? कभी तो मुझे ये लगता था insolvency professional have been reduced to a compliance officer only. You please comply with the code and the regulation made thereunder. Forget about anything else. And this is a wrong signal which is going amongst the insolvency professional community. I think an immediate corrective action needs to be taken. We all should have confidence in the code. We all should have confidence in our own regulator. But regulates the duty of the regulator to instill this confidence amongst all of us. If such disciplinary actions are taken, certainly it will be deterrent for all of us to comply with our duties, and we will simply become a compliance officer. कि CD के साथ जो कुछ होता रहे, हमें क्या फर्क पड़ता है? कल को एक्शन तो नहीं होगा ना, CD बंद हो जाएगा, कोई बात नहीं, doesn't make any difference. Let the company go into liquidation. Why should I mind? But that's not the objective of the code. We are also supposed to read and understand and implement the preamble of the code. Because the preamble of the code does not talk about liquidation. Preamble of the code is only corporate restructuring resolution only. Now, the other issue which is very close to my heart is there are at least 50 issues I can discuss, and for that I can discuss issue till tomorrow. One issue I would like to discuss right now is with respect to real estate industries. I think Sumit ji, आपके कलकत्ता में तो real estate वाले कम होंगे insolvency में, but हमारे दिल्ली में और NCR में तो लाइन लगी हुई है real estate वाले insolvency cases की.
Correct.
But एक trend जो मैं देख रहा हूँ यहाँ पर Northern India में real estate cases में अभी post these orders, और एक्चुअली ये बात मैं ना पिछले शायद 4 साल से कह रहा हूं मैं कि इंसॉल्वेंसी प्रोफेशनल का सबसे बड़ा दुश्मन जो है वो इंसॉल्वेंसी प्रोफेशनल है. आईपी इज एनिमी ऑफ आईपी, एंड आई एम गिविंग दिस स्टेटमेंट विद फुल कन्विक्शन. और मैंने स्टार्ट क्यों किया था ये कहना सिंस 2018 when the section 27 applications were being filed for replacement of resolution professional. Because under section 27, unfettered powers have been given to the committee of creditors. If the COC is not happy with the RP, COC may file an application by passing a requisite resolution with 66% of voting, file a copy of the resolution along with the application, and the NCLT will allow you to replace the resolution professional. No reasons being assigned, no principles of natural justice being followed. Simply pass a resolution, file an application, RP will be replaced. Now, RP's independence is a toss. RPs are really fearful. So tomorrow, if I do not follow the dictate of committee of creditors, the COC may file an application for my replacement. But here the question arises, this replacement can be done with another insolvency professional only. So unless the COC is carrying a consent from another insolvency professional, this replacement cannot be there. Now, this new insolvency professional who is giving his consent, should think twice before giving his consent for replacement. He should speak to the existing resolution professional that what are the reasons, why are you being replaced? What has been the conduct of COC? What has been the behavior of COC? Have you been paid all your outstanding dues? Have you been paid the CRP cost? Have you been paid your remuneration? हम प्रोफेशनल सर्कल में भी देखते हैं, वेदर वी आर CAC या CW और एडवोकेट्स, अगर कोई एग्जिस्टिंग असाइनमेंट आता है हमारे पास विच इज ऑलरेडी देयर विद अनदर प्रोफेशनल, either we take NOC or we intimate to the other party or we speak to him. But here in this case it's not happening. In this case the IPs are actually waiting for this कि कोई opportunity आए हमारे पास and I'll grab this opportunity. कोई COC member बोले तो सही consent देने के लिए, and I tell you some of the COC some of the IPs are giving the consent letter without mentioning the name of the corporate debtor. उन्हें मालूम ही नहीं है कि कहां उनकी consent जाने वाली है. Just simply sign the consent letter, give it to the person who is asking for it. Now what is happening after the DC orders in Delhi, खास करके in real estate cases? दो cases में देख चुका हूं मैं. The moment DC order comes, अब DC order says it shall be applicable, it shall be come into effect from the expiry on the expiry of 30 days from the date of the order. Now during this 30 days, this means the RP can convene a COC meeting. Now one meeting, COC, he convenes COC meeting because the resolution plan is already there. Resolution plan is already circulated among the financial creditors in class. Only thing is that plan के ऊपर voting होनी और कुछ नहीं होना है. Now at this stage DC order comes. अब जब DC order आता है तो CO this RP convenes a meeting of COC. अब जो AR है, now see his conduct. AR आता है COC meeting में और AR simply यही बोलता है, I'm here to discuss only your replacement, not any other agenda item. One of the agenda items was consideration of resolution plan. He says, I'm here only for your replacement. He says, how can you consider the resolution plan, my replacement? Where's the authority with you? My order shall come into effect after 30 days and you are an AR only. Agenda I will be fixing. He says, I'm COC. Can you believe it? He says, I'm COC because I have been appointed by COC. I'm carrying 100% mandate of COC. I will be discussing only your replacement, nothing more than that. And he carries with him 4 consent letters. तो अब ये देखिए 5 लोग अब इस एग्जिस्टिंग आरपी के पीछे पड़ गए बिफोर द एक्सपायरी ऑफ 30 डेज कि तेरे अगेंस्ट ऑर्डर आ गया है, अब तू निकल यहां से, वी आर रेडी टू टेक ओवर. This is one case. Another case that RP is very much present here right now. Real estate case, DC order is issued. Within 3 days, the AR writes to the resolution professional, convene a meeting of COC for your replacement. Think of this. This AR is talking to him, convene a meeting of the COC for your replacement. He denies. RP denies. The AR goes to NCLT and files an application without mandate of the COC. And he says, I'm filing this application under section 27 of the code. And if you read section 27, the resolution of 66% majority is required. But without any resolution, he files an application, the AR files an application under section 27 for replacement of this RP simply on the basis of he has been suspended. And now see, our adjudicating authority passes an order that you are a suspended member. You cannot convene a meeting of COC. You cannot wait for 30 days. We are hereby directing you to convene a meeting of COC within a period of 7 days from here. Now this RP has no other option but to convene a meeting of COC. He issues a notice of COC meeting as per the directions. Just a couple of days before the COC meeting, the RP is tested with corona positive. If he is corona positive, he is advised to isolate, because every now and then the government doctors are also calling him. At least 3 to 4 times the government doctors also calling him, where are you, how are you doing? He has to isolate himself. It means he cannot convene a meeting even through virtual board. He needs his office assistants. He writes to the AR as well as COC members in real estate that I am corona positive. Therefore, the meeting convened for such and such day stands postponed. I will issue a fresh notice of the next COC meeting and very next week. Once this communication goes, the AR writes to him, Mr. So-and-so, we have full sympathy with you. But as per the directions of the court, the COC meeting has to be convened. Think of this. This AR. And he's having now he's having consent also from one of the insolvency professionals to replace him. How can this AR be so inhuman that if one of the resolution professional is actually down with COVID, but AR says, sorry, you have to, as per the direction, you have to convene the meeting of the COC. So here my humble submission to and advice and request to all of you, first of all, we need to do some sort of introspection. We need to stand with each other. We need to hold each other's hand. अगर हम एक दूसरे को सपोर्ट नहीं करेंगे, एक दूसरे का हाथ नहीं पकड़ेंगे, एक दूसरे के साथ कोऑपरेट नहीं करेंगे, तो आउटसाइड एजेंसीज, वेदर इट्स रेगुलेटर और एडजुडिकेटिंग अथॉरिटी, सभी इसका फायदा उठाएंगे. And ultimately, it's we only who are going to be sufferers. So we need to decide how we have to behave. Are we going to be subject to these disciplinary orders, or we have to be united? We have to stand with each other and see this is not only this resolution, this code, but this profession also remains buoyant, and where this code and our profession both remain successful in the times to come. With this, I think time is going to be over. Sumit ji, over to you. If you're having any questions, I have a lot to discuss. Number of issues are there, but unfortunately, because of paucity of time, I'm not in a position to discuss those issues.
No, thank you very much. I think you have been able to fairly cover most of the important points. I'm sure that there are many such more points in the disciplinary orders, and it would take days to cover all such points. But thank you very much. If there are any questions, we can take it. Do we have any questions from the audience? You can just show your hand so that I can unmute.
Showing their hand, आपको unmute करना पड़ेगा.
Just a minute.
एक बार 5 मिनट के लिए अनम्यूट कर दीजिए सबको.
तरुण, अरुण अनम्यूट कर दो ना सबको.
Mr. Pratim Bail wants to say something.
So Lalit Maheshwari. Lalit ji, you can say.
Yes, sir. Good afternoon, sir.
Good afternoon, ji.
Sir, are you listening me, sir?
हाँ जी, बिल्कुल आपकी आवाज आ रही है.
But AR is appointed by RP, sir. He gives the 3 names of the authorized representative in the public announcement.
ARP is not appointed by RP.
No, but he gives the name.
RP 3 नाम मांगता है. 3 में से एक जो जिसको हाईएस्ट नंबर ऑफ वोट्स होते हैं, उसका नाम एडजुडिकेटिंग अथॉरिटी को भेजता है. अल्टीमेटली इट इज एडजुडिकेटिंग अथॉरिटी व्हिच अपॉइंट्स AR, not the RP.
Yes, sir.
Pratim Bayal ji. Arun ji, can you please unmute him?
Yeah. Good afternoon, sir.
Good afternoon, Pratim ji.
I think it was a absolutely very much interesting topic and topic for all the IPs nowadays. Sir, really the way the disciplinary actions are being taken up and this thing, there is a kind of concern for everyone and for we also. Is there anything, at least a basic principles? Okay, we conduct the CRP with almost ethical ground and all the compliance, but any key points that has to be kept in mind where we can just have some cushion to avoid these disciplinary actions. suppose filing the reports in time and all that, or it might happen. It might, we just keep our fingers crossed, it might happen to anyone like that. What I am saying, what I want to know, that is there any basic minimum things that has to be taken into consideration while conducting the CRP, specifically in today's context?
Pratim ji, iske liye, when we talk about corporate governance, the two primary pillars of corporate governance are transparency and disclosure. I think these two principles we need to follow. Whatever we do, this should be absolutely transparent. It should be disclosed to all the stakeholders. It should be properly recorded. और सबसे ज़्यादा आपकी मदद को क्या आने वाला है? I tell you your agenda notes and your minutes. In one of the cases I have seen, only on the basis of minutes, the inspecting authority ने कुछ नहीं किया, सिर्फ minutes उठा लिए और minutes में से उन्होंने loopholes निकाली. तो प्लीज मेरी रिक्वेस्ट यही है कि आपके एजेंडा नोट्स और मिनट्स के ऊपर जितना टाइम दें पॉसिबल उतना दें, जरूर जितना रिक्वायर्ड जरूर दें. एंड प्लीज एंश्योर दैट एवरी डैम थिंग इज रिकॉर्डेड देयर इन योर मिनट्स, so that कल को if you receive any show cause notice or prosecution notice or any inquiry also, you should be able to respond to that this already stands discussed and recorded in the minutes.
Very valid point. Creation of record is absolutely important.
Absolutely, yes.
So I think, Arun, we can proceed further. The next speaker, Advocate Sandeep Bajaj, is already here. Arun?
Yes, yeah. So I'll just introduce Mr. Bajaj.
Before that,
no, I think we offer a vote of thanks to GP.
Sure. So thank you, Mr. Madan. You are a well-acclaimed professional all over India, and it's a privilege that we could hear your views today. And you've covered all the points very nicely, and it's been very beneficial for all of us to hear these. And I'm sure all the fellow participants would have benefited greatly out of this. So I'll present an e-memento now, sir, to you, and I'll request all the participants to kindly carry this vote of thanks with a round of applause.
Thank you. Thank you. Thank you, everybody. Thank you so much. And I will wait for another opportunity also. So मुझे सच में बिल्कुल ऐसा लग रहा है जैसे घर में बैठा हूँ.
Thank you very much.
Thank you, sir. Thank you again.
I'll take your leave now because I have to go for another physical seminar now on IBC only.
Okay.
Right.
Saturday तो अब सेमिनार वेबिनार्स में ही हो गया है, बट अच्छा है, ठीक है, आपस में मिलते रहे, ज्ञान बांटते रहे, लेते रहे. It's good for everybody. I'm also student of law. संदीप जी आपसे तो कल परसों संदीप जी आपसे कल परसों मिल लेंगे कोर्ट में हम, और आपकी रिकॉर्डिंग जरूर सुनूंगा मैं. थैंक यू सो मच.
थैंक यू.
Thank you.
Sandeep,
this is video on.
Mr. Sandeep Bajaj
also.
Sandeep is there.
Yes, I've made him a co-host as well.
Okay. Oh, let me just call him. Yeah. He's there. He's there.
So, unmute. Now I'm on mute, sorry. So I was just trying to unmute myself, so there's some problem issue which was coming up.
Welcome, Sandeep. Welcome.
Thank you very much, sir. Thank you. Hello, everyone.
Hello.
So Sandeep, we'll just introduce you. I think Arun, please take it forward.
Thank you. So on behalf of Association of Corporate Advisors and Executives, we welcome Mr. Sandeep Bajaj, advocate from he's attending and addressing us all from Delhi, I think. So Mr. Bajaj is a first generation. I'll just read this profile, although it's quite elaborate, but maybe
I don't think so, Arunji, that's required, but I just introduce myself. I am a lawyer, student of law, practice mainly on company law, insolvency law, and arbitration law. So that's enough, I think, Arunji. I don't think so. We need any other introduction.
That's great. So kindly take over from here and please present. And you are the co-host now, so you can launch your presentation as well. If
sure, please. No, I'll just screen share a few judgments because my issue is very interesting. And in fact, a lot of litigations going on in this respect. So I just want to bring to the latest updates regarding the judicial issues in respect of personal guarantors. So I was just going through the recent IBBI paper and some interesting facts. See, total 5,258 CIRPs have commenced by the end of March 2022. Of these, 3,406 have been closed. 731 have been closed on appeal or review settled. 586 have been withdrawn. 1,609 ended in order of liquidation, and 480 have been ended in approval of resolution plan. So out of these 1,600 which has ended in resolution, in liquidation, and 480 which has ended in approval of resolution plan, I can feel that most of these cases, the creditors have not been able to recover their entire debts. Here comes the issue regarding the personal guarantees. See, we all know most of the debts have been granted on the basis of the personal guarantees furnished by directors, promoters, and other related parties. So, but when we go to the data relating to personal insolvency, the IBBI paper says only 926 applications have been filed as of March 31, 2022. 82 have been filed by debtors, 844 applications filed by creditors. Among them, 18 have been filed before DRT and 908 have been filed before the NCLTs. So around 1,000 applications have been filed in respect of personal guarantors. And 2,000, more than 2,000 CIRP which ended in liquidation or approval of resolution plan. But when we talk about the CIRP, around 2,000 have been resolved also, ultimately ended in liquidation. But in respect of the personal guarantee, I don't think so. There is even a single CIRP, I mean, insolvency resolution process of a personal guarantor, which has concluded till date. And the sole reason regarding that is the litigation which has been going on in relation to the personal guarantors from the very beginning itself. So we are just discussing these issues, why individual insolvency relating to personal guarantors could not be concluded till date, what are the issues which had arisen, and what are the litigation which are going on from the very beginning. Firstly, what happened is 15th November 2019, government issued a notification making the provisions of Part 3 applicable to personal guarantors. Part 3 relates to individual and partnership firms. So in relation to individuals, we all know the insolvency provisions have not been notified yet, but they carved out an exception. They made this Part 3 applicable for personal guarantors to the corporate debtor. So the first issue arose that whether government by notification can categorize the individuals into two parts, whereas in relation to personal guarantors, they have notified the Part 3, but in relation to other individuals, the Part 3 has still not been notified. So that matter went up to Supreme Court, several writ petitions were filed, and ultimately judgment came to be passed in Lalit Kumar Jain judgment. I'll share the relevant para, but before that, the interpretation before the Supreme Court was Section 1, Subsection 3. Section 1, Subsection 3 entitles the government to notify the different provisions of the code, making it applicable to different, making the provisions applicable at different times. But the question here was whether government can further categorize the individual into two parts. And if you see the relevant paras of Lalit Kumar Jain judgment, my learned friend is just sharing the Lalit Kumar Jain judgment on screen. You have Arunji, can you enable screen sharing? There is another system which has been logged in the name of Sandeep Bajaj. If you can just permit the screen sharing on that.
Yes, I have made him the co-host, so you can share your screen now. Yes.
See, the issue has been captured in para 7 itself. I'll just read the relevant parts because this issue is now finally settled. First was the petitioner argued that the power delegated under section 1 subsection 3 is only as regards the points in time when different provisions of the code can be brought into effect, and that it does not permit the central government to notify parts of provisions of the code or to limit the application of provisions to certain categories of person. The impugned notification, however, notified various provisions of the code only insofar as they relate to personal guarantors to the corporate debtor. It is therefore ultra vires the provisions to section 1 subsection 3. So that was the whole issue before the court, and in fact everyone limited their arguments only to challenge of the notification itself. So ultimately the Honorable Supreme Court in para 100 upheld the notification while upholding the power of the government to issue such kind of notifications. If you see the para 100, it is clear from the above analysis that parliamentary intent was to treat personal guarantors different from other category of individuals. The intimate connection between such individuals and corporate entities to whom they stood guarantors, as well as possibility of two separate processes being carried on in different forums with its attendant uncertain outcomes, led to carving out personal guarantors as a special species of individuals, for whom the adjudicating authority was common with the corporate debtor to whom they had stood guarantee. The fact that the process of insolvency in part 3 is to be applied to individuals, whereas process in relation to corporate debtors set out in part 2 is to be applied to such corporate persons, does not lead to incongruity. On the other hand, there appears to be sound reason why the forum for adjudicating insolvency process, the provisions of which are disparate, is to be common, that is through NCLT. As we emphasized during the hearing, the NCLT would be able to consider the whole picture, as it were, about the nature of the assets available, either during the corporate debtor's insolvency process or even later. This would facilitate the COC in framing realistic plans, keeping in mind the prospect of realizing some part of creditors due from the personal guarantors. In view of the above discussion, it is held that impugned notification is not an instance of legislative exercise or amounting to impermissible and selective application of provision of the code. There is no compulsion in the code that it should at the same time be made applicable to all individuals, including personal guarantor, or not at all. There is sufficient indication in the code by section 2E, 522, section 60 and 179, indicating that the personal guarantor, though forming part of the larger grouping of individuals, were to be, in view of their intrinsic connection with corporate debtor, dealt with differently through the same adjudicating process and by the same forum as such corporate debtor. The notification under section 1.3 discloses that the code was brought into force in states regard being had to be categories of persons to whom its provisions were to be applied. The impugned notification similarly make the provision of the code applicable in respect of personal guarantor to corporate debtor as another such category of persons to whom code has been extended. It is held that the impugned notification was issued with the power granted by the parliament, invalid exercise of it. The exercise of power in issuing impugned notification under section so and so is therefore not ultra vires. The notification is valid. So with this, new process started. Several demand notices were started and creditors started taking the steps under section 95 of IBC. But then comes the another problem. If we all see section 79 of the Insolvency and Bankruptcy Code, which provides the definition in part 3, it still defines the word adjudicating authority. And the parliament in its wisdom has made two different adjudicating authorities for individuals and for the companies. So section 79 in part 3 for individuals defines the adjudicating authority as debt recovery tribunal. So the question came that in relation to the personal guarantors, whether the adjudicating authority would be DRT or it would be NCLT. For that, further section 95 says the application shall be filed 79%. application shall be filed before the adjudicating authority only. Section 79 simply says adjudicating authority DRT. Then if you see section 179 also again in part 3, it says which DRT has the jurisdiction. Section 179 in part 3 deals with the subject to provision of section 60, the adjudicating authority in relation to insolvency matter of individuals and firms shall be DRT, having territorial jurisdiction over the place where the individual debtor actually resides. So the question came, in relation to the personal guarantor, what will be the adjudicating authority? So answer lies in section 60. Section 60 in part 2 provides that NCLT shall be the adjudicating authority in relation to the corporate debtor as well as corporate guarantor and the personal guarantor to the corporate debtor. Section 60 subsection 1 says adjudicating authority in relation to insolvency resolution and liquidation for corporate persons including corporate debtor and personal guarantors thereof shall be the NCLT having territorial jurisdiction over the place where the registered office of the corporate person is located. Subsection 2 further provides that without prejudice to subsection 1 and notwithstanding anything to the contrary contained in the code, where a corporate insolvency resolution process or liquidation proceeding of a corporate debtor is pending before NCLT, an application relating to insolvency resolution or liquidation or bankruptcy of a corporate guarantor or personal guarantor, as the case may be, of such corporate debtor shall be filed before such NCLT. An insolvency process or liquidation of a bankruptcy proceeding of a corporate guarantor or personal guarantor, as the case may be, of the corporate debtor, pending in any court or tribunal, shall stand transferred to adjudicating authority dealing with the insolvency resolution process or liquidation proceeding of such corporate debtor. Then subsection 4 provides the NCLT shall be vested with all the powers of DRT as contemplated under part 3 of this code for the purpose of subsection 2. So this section 16 makes it clear that in relation to personal guarantor, subsection 1 simply says it will always be NCLT. But 2 provides us some kind of exception. 2 says where the CIRP proceedings are pending before a particular NCLT, all the proceedings of personal guarantor will also go with that. But the further confusion arises when the central government issued the rules relating to the personal guarantor of the corporate debtor. In the rules, they provide the definition of adjudicating authority again. And my learned friend is just sharing that rules also. In the rules, again, they provide 2 kinds of adjudicating authority in relation to personal guarantor only. One, DRT, and second is NCLT, where the CIRP proceedings are already pending against the corporate debtor. So an argument was raised by several personal guarantors where either the CIRP process has not begun or where it has already been concluded by the resolution plan, raising a contention that in terms of this rules also, which has been framed by the government, it says rule 3 says adjudicating authority means for the purpose of section 60 National Company Law Tribunal constituted under section 408 in cases other than subclause 1, because it is related only to the personal guarantors. Other category means where it is not covered under section 60, where no CIRP is pending. It says DRT. So it envisages 2 forums. So everyone raised an objection where CIRP is not pending. Even those cases where resolution process plan has been approved, there, as per various judgments, that CIRP comes to an end the day the resolution plan is approved by NCLT. No proceedings are pending before the NCLT. So everyone started questioning it, that this tribunal do not have the jurisdiction and the proceedings can lie before the DRT. Then comes the judgment. Of course, it's a celebrated judgment now, originating from the Kolkata NCLT only, in the matter of Jajodias. In Jajodia, this issue was finally settled by Conclave, where it says section 60 subsection 1 is very clear provision, where it says that para 7 onwards. Subsection 1 of section 60 provides adjudicating authority for the corporate persons, including corporate debtor and personal guarantor, shall be NCLT. Subsection 2 of section 60 requires that where a CIRP or liquidation process of the corporate debtor is pending before a national company law tribunal, the application relating to CIRP of the corporate guarantor or personal guarantor, as the case may be, of such corporate debtor shall be filed before such NCLT. The purpose and object of subsection 2 of section 60 of code is that when proceedings are pending in a NCLT, any proceedings against corporate debtor should also be filed before such NCLT. The idea is that both proceedings be entertained by one and the same NCLT. The subsection 2 of section 60 does not in any way prohibit filing of proceedings under section 95 of the code, even if no proceedings are pending before NCLT. The use of the words a and such before NCLT indicates that section 60 subsection 2 was applicable only when CIRP or liquidation proceeding of a corporate debtor is pending before NCLT. The object is that when a CIRP or liquidation proceeding of a corporate debtor is pending before NCLT, the application relating to insolvency process of a corporate guarantor or personal guarantor should be filed before the same NCLT. This was to avoid two different NCLTs to take up the CIRP of a corporate guarantor. Section 60 subsection 2 is applicable only when CIRP or liquidation proceeding of a corporate debtor is pending. When CIRP or liquidation proceeding are not pending with regard to the corporate debtor, there is no applicability of section 60 subsection 2. Subsection 2 begins with expression without prejudice. Thus, provision of section 60 subsection 2 are without prejudice and are supplemental to subsection 1. Subsection 1 of section 60 provides that adjudicating authority in relation to insolvency or liquidation for corporate debtor, including corporate guarantor or personal guarantor, shall be the NCLT having territorial jurisdiction over the place where registered office of the corporate person is located. The substantive provision for the adjudicating authority is section 60, subsection 1. When a particular case is not covered under section 60, subsection 2, the application as referred to in subsection 1 of section 60 can be very well filed in NCLT having territorial jurisdiction over the place where registered office of the corporate debtor person is located. The adjudicating authority erred in holding that since no CIRP or liquidation proceeding or CD are pending, the application under section 95, subsection 1, filed by the appellant is not maintainable. The application having been filed under section 95(1) and the adjudicating authority for application under section 95 as referred to in section 61 being the NCLT, the application filed by the applicant on the ground that no CIRP or liquidation proceeding of the CD are pending before NCLT. In the result, we set aside the order dated so and so passed by adjudicating authority. The application filed by the appellant under section 95 of the code is revived before the NCLT, which may proceed in accordance with law. So ultimately, this matter went up to Supreme Court. Supreme Court initially granted a stay, which led to the almost stay of all the proceedings which are pending before the NCLT. This was the first order which was passed. It says issue notice until further order, there shall be stay of the operation of the impugned order passed by the NCLT. Now this matter went up to several months, where not even a single application was taken up before, by the learned adjudicating authorities. They were simply adjourning the matters on the basis the matter is pending before Supreme Court and no one knows which forum have the jurisdiction in this respect. But ultimately, Supreme Court dismissed the SLP, thereby upholding the order of the NCLT. So it's a simple order. They say that we have heard the learned Solicitor General and learned Civil Counsel for the party and peruse the record. We do not see any cogent reason to entertain the appeal. The judgment impugned does not warrant any interference. The appeals are dismissed. So this settles the law that in relation to personal guarantors to the corporate debtor, the adjudicating authority will always be NCLT. However, till date, not even a single judgment has dealt with the rules framed by the government. No one has held that the rules are ultra vires to the code or not. They simply upheld the judgment passed by NCLT. Section 60, subsection 4, which confers the jurisdiction on the NCLT in respect of the personal guarantors have also not been discussed. This issue, I don't know when, maybe may arise in future, but as of now, law is well settled that only NCLT has the jurisdiction, and a recent judgment, again, Conclave has reiterated this law, discussing the complete law in this respect, including the judgment of Lalit Kumar Jain, and again upheld that section 60 is very clear, and in view of section 60 subsection 1, whether CIRP proceedings or liquidation proceedings are pending or are not pending, the adjudicating authority in relation to the personal guarantor would always be NCLT. So that has been a second round of litigation completed. Just show the title of this.
So Sandeep, just to clarify and for the benefit of all our participants, so no personal guarantor case can be filed with any DRT. That's the underlying assumption and the conclusion of all these orders from Supreme Court and from the NCLAT.
Arunji, interestingly, that's why I read with the IBC paper first. There are 18 applications still pending before DRT. In fact, judgment of NCLAT may not be binding upon DRT. And in view of the rules framed by the government, DRT can still proceed. Because appeal against the DRT order will lie before the DRAT. Right. Whether this judgment of NCLAT, because Supreme Court, what the Honorable Supreme Court has done is that simply dismiss the civil appeal. They have not passed any law. So ultimately, what is the final judgment is of NCLAT to hold this issue.
Right.
And DRT are still proceeding with the matter. So there is still a confusion. Someone needs to interpret the rules also. Rules has not been interpreted. And finally, when the Supreme Court judgment comes, I think this issue will also be sorted. But as of now, both are going ahead. But NCLT now cannot reject on this basis, saying that the NCLT doesn't have a jurisdiction. So whether DRT has the jurisdiction or not, that has not been discussed anywhere.
That vertical will need to travel its own course.
Correct. That would travel its own course. Ultimately, if someone goes to DRT or a Supreme Court, that will be decided later.
That will be decided. Absolutely. Thank you so much.
So this has been a second round of litigation which has delayed the conclusion of proceedings against the personal guarantor. Now, after this, again, the creditors thought that they'll still be able to proceed now. At least they'll be able to conclude the proceedings in relation to the personal guarantors. So they started filing the applications. In view of the applications, even RPs were appointed. Then another litigation ensued that you cannot appoint the RP without giving any personal opportunity. But NCLAT in those judgments have settled the law. Only limited notice is required to be issued. After the limited notice, resolution professional can directly be appointed who can file the report. So now when these issues were going on, then a third round of litigation started now. Everyone started approaching Supreme Court by challenging the constitutional validity from 94 to 100. On this basis itself, on the basis of NCLT and NCLAT judgments, where they say that no opportunity is required to be given, and it has not been envisaged under the code itself that any opportunity be given to the personal guarantors to make any submission at the stage of 95, that will be given only at a stage of 100. Now, once the matter approached before the Supreme Court, the Honorable Supreme Court again passed an interim order. And this is the interim order which is going on at this moment, and the matters are still pending. Every day, actually, every Monday and Friday on a miscellaneous day, at least 3-4 matters are listed and a similar orders are being passed. If you see that, here the interim order has been passed, issue notice, returnable in 6 weeks, tag with SLP so-and-so. In the meanwhile, petitioner shall not transfer, alienate, encumber, or dispose of any of his assets or his legal rights or beneficial interest therein, and the resolution professional shall not proceed with filing of the report. So this is the latest issue which has gone before the Supreme Court. Now, at this moment, at least 30-40 matters are already pending, and every day new matters are being filed either before the Supreme Court and in Kolkata High Court also, where similar leaves are being granted. So now again this process has been stopped, holding that whether these provisions are constitutionally valid or it's unconstitutional. If you'll see section 95, 95 simply says a creditor may apply either by himself or jointly through a resolution professional to the adjudicating authority for initiating an insolvency resolution process under this section by submitting an application. A creditor may apply under subsection 1 in relation to partnership. 3 says where an application has been made against one partner, any other adjudication against another partner in the same form shall be presented in or transferred to the adjudicating authority in which the first mentioned application is pending. Then 4 says it will be accompanied with the detailed information of other documents required. 5 also provides that provide a copy of the application made this shall be in such form, and 7 detail and documents required The moment this application is filed, another interesting question comes is interim moratorium kicks in. Where an application is filed, this is on the filing of the application itself. Under section 94 or 95, an interim moratorium shall commence on the date of application in relation to all the debts. This is a departure from the CIRP process where after the application is admitted, only then the moratorium kicks in. Here, the moment application is filed, interim moratorium kicks in. That has been the main basis to challenge these provisions before the Supreme Court, and a new stay has been granted, and the proceedings are still being halted. So again, the NCLTs are not able to move further, and proceedings in relation to personal guarantors has not begun. So this has been a third round, which is pending. Now, along with this, another interesting issue has arisen in view of one of the DRT judgment. The question comes, this is now settled law, company goes into liquidation, entire debt is not being recovered by the creditors. Creditors are entitled to go against the personal guarantors. This has been upheld in Lalit Kumar Jain judgment, where the issue has arisen whether the personal guarantors, they do not have any right of subrogation. Can a proceeding be initiated against them because their debt gets discharged the moment resolution plan is approved? And they also have a right to get the right of subrogation, and in case principal borrower is discharged, their liability should also be discharged along with that. That has been repelled in Lalit Kumar Jain judgment. And so Honorable Supreme Court has said that this is section 31 says once the resolution plan is approved, it's binding on everyone. So in that scenario, no right of subrogation is available to the personal guarantor, and the proceedings against the personal guarantors are valid proceedings. But before the DRT Ahmedabad, in a recent judgment, another issue arose. The issue was, if I just read the few facts, this is a very interesting issue, where it says the OA has been preferred by the applicant bank under section 19 of the RDB Act, seeking recovery of an amount from the defendant number 1 by invoking the personal guarantee executed in favor of the applicant bank. Defendant number 1 had executed a personal guarantee and guaranteed the amount due and payable by so-and-so under various credit financial facilities. 8th March, NCLT with a common judgment approved the resolution plan. Honorable NCLT has approved the resolution plan on various conditions. Then order has been challenged before the NCLT and this process has been provided. Then copy of the relevant extract of resolution plan they have quoted. They have also provided what happened before the Supreme Court. We can just skip this part. During pendency of the present proceeding, defendant number 1 had preferred a writ petition before the High Court seeking a writ of prohibition on the ground mentioned therein. The petition was dismissed by the judgment. So we can skip this part also. And a relevant part, if we straight away come. Para 4. In view of the aforesaid directions issued by the High Court, the defendant has raised the following questions before the tribunal for consideration. Having assigned the debt as defined under section 2G of RDB for valuable consideration as part of the resolution plan under Insolvency and Bankruptcy Code, is the OA maintainable? Alternatively, having relinquished its right and or entitlement to pro rata receive the cash balance earned by so-and-so, as more particularly set out herein, are the defendant discharged of their liability under the personal guarantee, whether absent the existence of jurisdictional fact, namely debt, as defined in section 2G, either on account of assignment and or extinguishment and or discharge by relinquishment, does this tribunal have the jurisdiction to entertain the OA? Now, the DRT Ahmedabad has given the finding. That's interesting finding. We'll straight away come to the finding part only. This is the jurisdiction, that's fine. You can just skip this part. Just skip this part also. Just come to the findings straight away. Next after this. So, next paragraph. Para 20. Hence, the learned counsel for the defendant submitted that, as described in the table, the entire liability of all secured financial creditors stands discharged. He further submitted that applicant banks are part of the secured financial creditor, and therefore their liability also stands fully discharged. Per contra, applicant banks have submitted that the applicant bank has still to recover the outstanding amount by way of interest from the guarantors defendant as on so and so as per the details submitted. Therefore, according to the applicant, defendants are still liable under the personal guarantee executed by them. In this context, it would be worthwhile to refer to the all relevant clauses of the assignment agreement, because that was assigned by the banks to a third party. These are standard clauses which will be found in almost all the assignment deed. The above assignment deed executed and signed by the secured creditor clearly shows that the secured creditor have assigned the entire amount receivable from the corporate debtor, that is principal, interest, other charges, and any other payment under the facility agreement. All rights of the secured creditor in respect of the said debt have been assigned. After assignment, there is no debt due to the secured creditor. If there is no debt due by virtue of assignment, there are no amounts which can be claimed by the applicant bank, either from the corporate debtor or from the guarantors. The entire liability stands discharged vis-a-vis the secured financial creditor for principal, interest, and any other amount due under the facility agreement. The above clause further demonstrates applicant bank had no debt due and recoverable from the principal borrower or assignment of debt after the approval of resolution plan. As per section 128 of the Contract Act, the liability of the surety is coextensive with that of the principal borrower. When the applicant banks have discharged the principal borrower from its entire liability by assigning the debt to so and so, the guarantee given by the defendant for payment of such debt do not survive and the defendant stands discharged. So this has opened a new line of arguments where the question is now, when the debt is discharged by assignment, or if the resolution plan mentions the provision regarding the discharge of debt, can the lender still invoke the personal guarantee? And if they invoke the personal guarantee, whether they'll be able to proceed against him in DRT as far as OA is dismissed. Once the recovery proceedings are dismissed, whether still can they go against the personal guarantor under the Insolvency and Bankruptcy Code, because the entire IBC is on the basis of a debt and default. If there is no debt or there is no default, then even the NCLT cannot proceed. So once the recovery proceeding court has said that there is no debt and there is no default, then of course there cannot be simultaneously proceeding against the IBC. So this is another line which has just begun. We'll have to see where it goes as far as the courts are concerned. So that will be a fourth round of litigation which is still going on, and there will be a lot of problems still where the proceeding against the personal guarantor can be concluded. So these are the issues at this moment which are going ahead. We can legal years. Now another interesting question has arisen recently regarding the proceedings, whether it can continue against the legal year or not. Though of course there is not much judgments, but if we read it, one or two NCLT judgments, we can just one of the two NCLT judgments, you can show the para, has said that the proceeding cannot continue if the person is deceased. So the question was framed by NCLT Kolkata again, because NCLT Kolkata has been a pioneer in the development of IBC, and the most of the interesting judgments are by the NCLT Kolkata. Another this issue in question comes upon perusal of the report. The question arising before this adjudicating authority is whether petitioner is entitled to recover the dues of the corporate debtor from the legal year of the personal guarantor. With regard to the above contention, it is pertinent to throw light on the following provisions. They have to just mention a provision. When para 17 says, when a section 95 application is filed, the assets of the personal guarantor is hit by moratorium. And if we put the legal heirs of the deceased personal guarantor into the shoe of the personal guarantor, then their personal assets will also get automatically hit by moratorium, which will cause grave prejudice to the rights of the third party. However, there is no provision in the code which envisages that the concept of legal heir stepping into the shoe of the deceased personal guarantor. In the instant case, the petitioner can take appropriate steps to recover the guaranteed amount from the asset estate of the deceased personal guarantor, rather than the personal assets of the legal heirs of the personal guarantor. Further, the legislature is very much clear in defining the term personal guarantor. The code talks about the estate assets of the personal guarantor only. Therefore, we hold that instant application cannot be maintained against the legal heir of the personal guarantor under the code, and the remedies may lie elsewhere. So that's another interesting issue, which says that as far as legal heirs are concerned, the proceedings cannot continue against the legal heirs in case the personal guarantor is deceased. So these are the issues which are going on. If anyone has any question, we can take the question.
Yeah, Arun, we can unmute everyone for the time being. So if they have any questions, they can put it forward before Sandeep. Anybody having any question?
Kindly unmute yourself. You can unmute yourself and ask the question.
Yes, in case of personal guarantor, where the NCLT has given the opportunity before admission under Section 99, whether the stay by the Supreme Court will continue on them also, or it will not be there because the opportunity has already been given.
See, the interesting question is at this moment, they are discussing the constitutional validity, whether the provisions are valid or not. So, therefore, Supreme Court says if these provisions are not constitutional, then in any case the proceeding cannot continue. So, the factual question, whether the opportunity is granted or not granted, is not being discussed there. It's simply on a ground if the provisions are constitutional or not. Only that question is being decided.
If the RP is appointed under Section 99 and he is asked to submit the report by the NCLT order, and he has submitted the report, whether that will be tantamount to the.
What happens is, interestingly, last hearing, few of the such cases have also come before the Supreme Court, where it was said that the report has already been filed because the Supreme Court has restrained the RP to file the report. But where the report has been filed, what would happen to those cases? The Supreme Court has directed the NCLT not to consider the report till the time these matters are pending. So those matters have also now been stopped.
So there will be no further action by the NCLT at the moment.
No further action can be taken by NCLT in respect of only those persons who are approaching Supreme Court. Few cases have gone to Kolkata High Court also. Kolkata High Court is also granting the similar relief.
So those will be applicable only on those cases where they are approaching Supreme Court, not otherwise.
Not otherwise. This is limited to the petitioners only.
Okay, so they have to travel through NCLT first, then they will go to the Supreme Court.
No, now earlier first round has gone through the civil appeal or SLPs. Now everyone has started approaching through writ petitions also. Supreme Court is passing the similar order.
Yes, Lalit Maheshwari ji, you can ask a question, please.
Sir, there is one provision on the death of the personal guarantor. This proceeding will not abate.
Sir, interestingly, those are the provisions in bankruptcy,
yes,
not
sir.
through the insolvency. So if you see the provisions, actually in bankruptcy, it is provided once the bankruptcy proceeding starts. Because of what happens is, during insolvency, they are trying to find out the repayment plan. But in bankruptcy, there is a bankruptcy trustee who takes over the control of the assets of only the personal guarantor. Their bankruptcy proceeding says it will not be abated, it will continue because what you are doing at that stage is just selling the assets of the bankrupt. You are not proceeding or insolvency proceeding against that.
Yes,
so
sir.
that's still a laguna, it will be decided, yes.
Yes, sir. There is one question. Someone has filed application under Section 94 and RP gives the report under Section 99. Executing authorities always say it is incomplete report. He tries his best. He has given the emails to all the bankers or creditors, but he did not receive anything. So what in that report, what he should write? So executing authority cannot deny the report.
Sir, interestingly, what happens is there is another line of conflict which will definitely rise in future. As of now, people are enjoying this state, so they are not raising this issue. When an RP is preparing a report, the question comes, the RP at that stage is preparing report only in relation to the applicant, not in relation to the other creditors.
Yes, sir.
What it says is, looks after the assets of the persons, whether the debt has been discharged or whether he is in a position to discharge the debts, whether that person has become insolvent or for what reason this payment is not being made. Because generally what my personal experience have been, I have been dealing with several personal guarantee matters. And interestingly, RP is not sending the letters to the personal guarantor. In most of the cases, just 1 or 2 letters saying that, okay, you provide us your return for the last 2-3 years. If you provide, that's okay, otherwise the report is being filed. So if you have the return for the last 3 years, you can simply say that applicant, in most of the cases, banks approach the NCLT. That much net worth is never there with the promoter. It's just an empty formality, filing a report. Everyone knows the moment bank approaches before the NCLT asking for hundreds or thousands of crores, the promoter doesn't have that kind of fund. So if you're providing that even the applicant itself, they are not able to provide this kind of fund, then the proceeding should continue.
it means the executing authority should accept the report of the RP.
Correct. But there is a provision, sir. If the detail is not being provided, you can still file a non-cooperation application against it.
Okay, sir. Thank you very much.
Sandeep, there's a question in the chat box that can a personal guarantee case be filed without filing CIRP and NCLT? I think yes.
Yes. Now it is settled because that's why I read the judgment of Jajodia. In that, everything is settled if it is being filed in the capacity of personal guarantor. See, there are two possibilities. One is in the capacity of individual has taken a loan, or number two, it is on the basis of a personal guarantee he has furnished in respect to the corporate debt. If he has given the personal guarantee on that basis, any proceedings are being filed, that only NCLT will have the jurisdiction in view of the entire judgment of Jajodia.
On being appointed under Section 99, RP has to give the report on the basis of the requisition by the RP from the guarantor under Section 99(2) regarding whether they have made the payment and all those informations. Apart from that, no other information is normally being given by the guarantor, and there is no mean of getting the details of the individual guarantor. Secondly, normally when he is in default, he is not paying the money, he is not responding. So under the circumstances, the RPs are filing the report basis only that they have not got any information from the for the demand raised by under Form B by the creditor. So it is being amount to that they are in default and they are recommending for the admission of the cases.
Yes, sir. Absolutely. You're absolutely right. This is the regular practice also. NCLT normally have been accepting the report, but what happened is because of these days, it has not forwarded much. Yes. So matter still stands still at this moment. But so this DRT issue, now new assignment of debt and whether the creditors are still entitled for the amount, that's a new interesting issue, sir, which will come up definitely in near future.
I don't think there are any more questions. Nobody else is raising their hand also. And there's nothing in the chat box as well. Right. So thank you, Sandeep ji, for sparing your time and sharing your views with us. I think all the participants, just like me, have greatly benefited from these deliberations. And I hope that you will again come back when we request you in future. And will again be beneficial of those deliberations in the future as well. And we'll keenly watch what's happening in this space of personal guarantors. Certainly, it's certainly not something that has come to an end. There are many more layers to it, which have to unravel themselves. So thank you so much. And I like all the participants to kindly carry this vote of thanks with a round of applause. I'll present the memento to Mr. Sandeep Bajaj.
Thank you. Thank you very much, Andy. Thank you.
Thank you so much.
We've got very interesting session coming up on the direct tax implications on the CRP and liquidation.
We had a very interesting session yesterday on the indirect tax aspect. So today is the direct taxes aspect, which again is very integral to the whole insolvency process. So if Mr. Sandeep is here.
Yeah,
Arun, let me take the trouble of saying something. Sorry for interrupting you.
Yes, Sandeep ji.
Friends, my name is Sandeep Khemka. I'm a chartered accountant and practicing tax since last 20 years. And thanks to Sumit ji for giving me this opportunity to speak here and address this August gathering. I will be speaking on the interplay of the provisions of Income Tax Act along with the IBC. So as we all know, tax always comes after business. So even in the statutory accounts, it is profit before tax, and after that, it is provision for taxation. However, in most of the cases for important business decisions, somehow tax always plays a major role, and at sometimes it is a make or break role, and therefore very important part of all business decisions. Similarly with IBC, while IBC has come with all good intentions, it is very important to have tax implications arising out of IBC be kept in mind to ensure that the resolution process and the resolution plan is effective and efficient at the time of implementation. We all know that IBC overrides tax laws. 238 of the IBC and Supreme Court in Monet Ispat and Duncan Industries have clearly laid out this part. Coming to the moratorium on tax proceeding and filing of appeals, Section 14 of the IBC clearly provides for moratorium and prohibits continuation of the pending suits of proceeding and institution of fresh suits of proceeding, and income tax is no exception, upheld by Monet Ispat, upheld by Delhi High Court and confirmed by Supreme Court in Monet Ispat. In Ghanshyam Mishra, what is important to note is that the court specifically clarified that no proceeding in respect of the dues for the period prior to the date of approval by the NCLT can be continued. Now, there are two time zones. It is two time zones which needs to be kept in mind. One is prior to the admission for the CIRP proceedings, and one is the intervening period between the admission and the final approval of the resolution plan. In Ghanshyam Mishra, it was specifically worded by the Supreme Court that up to the approval by NCLT, there will be no proceeding and moratorium remains. There is one important judgment which has come very recently, and I would just like to highlight because it is very, very critical. It is against the flow of the river and very important for resolution applicant as well as the IPs to keep in mind. This decision came on 17th of June 2022 by Madras High Court in the case of Dishnet. So I'll just briefly touch upon the fact of the case. The CIRP process was admitted on 12th of March, and Income Tax Department issued reassessment notices under Section 148 for assessment year 11-12, 12-13 and 13-14 on 27th of March. So it was after the admission of the CIRP proceeding. Assessee challenged the reassessment proceeding by way of writ petition on 26th of December, and interim orders was passed by the Madras High Court on 27th of December, whereby the court allowed the Income Tax Department to proceed with the reassessment proceeding, however directed that the assessment order shall not be issued and will be kept in a sealed cover. The resolution plan was finally approved on 9th of June 2020, and thereafter the court held, and I'm just reading the relevant part of the decision which says, highlights of the decision which says that resolution plan has not contemplated any concession from the Income Tax Department, though notices under Section 148 had already been issued. Approved resolution plan did not contemplate tax issues under the IT Act. Since the proceeding under the code were initiated by the petitioner few days prior to the initiation of 148 proceeding, it was incumbent for the petitioner to have ensured proper notice to the Income Tax Department and obtained appropriate concession in the insolvency proceedings. Claims of the Income Tax Department were not considered by NCLT Mumbai while approving the resolution plan, and therefore the question of abatement of such rights of the Income Tax Department cannot be countenanced. Provisions of Insolvency Code cannot be interpreted in a manner which is inconsistent with any other law for the time being in force. Therefore, the corporate insolvency resolution plan sanctioned and approved cannot impinge on the rights of the Income Tax Department to pass any fresh assessment order under Section 148. Therefore, IBC cannot be used to dilute the right of revenue to reopen assessment under Section 148. The court further went ahead and said, if the petitioners are aggrieved by the assessment order, they have an appellate remedy before Commissioner of Income Tax Appeals. Now, this is a very strange decision, and with all due respect to the Madras High Court, if ultimately the law, if this becomes the law, it will have a very far-reaching impact on the IBC proceedings, and it is very likely that an appeal or an SLP will be filed before the apex court soon. However, till this judgment is dissented with or overruled or something happens, it is a litigated matter, and always advisable for all resolution applicants, including the IP, that this should be carefully factored in the resolution application. Another small change that has happened under the Income Tax Act is the introduction of Section 156A by the Finance Act 2022 with effect from 1st of April 2022. Now, in case of many business reorganization, including the IBC proceedings, liabilities are recasted to ensure future viability of such sick entities. This also results in recasting of the demand raised by income tax department under various proceedings. Now, when this liability is recasted, there is no procedure or mechanism under the Act to reduce such demand from the register of the income tax department. And therefore, to provide a mechanism, this 156A was introduced, which provided that where any tax interest penalty in respect of which a notice of demand has already been issued under section 156 is reduced as a result of an order of the adjudicating authority under IBC, the assessing officer shall modify that demand and issue a revised notice under section 156A, which shall be deemed to be a notice issued under section 156. So by this mechanism, the demand of the income tax raised by the income tax department gets realigned with the resolution plan approved by the adjudicating authority. Another important section that has come in is introduction of section 170A, that is 170A, again by the Finance Act 22 with effect from 1st of April. Now, it talks about filing of a revised return post the approval of the resolution plan by the adjudicating authority. Now, after any reorganization, affairs of the successor entity always go through a complete change. And because of the indefinite timeline involved in the entire process, there is always a gap between the institution of the proceeding and approval of the final order. And during the intervening period, it is the corporate debtor who have to close his accounts and even the tax returns are filed. But once the resolution plan is approved, there is the time limit to revise the income tax return lapses under section 139. And it becomes very difficult for the corporate debtor to revise this income tax return in line with the approved resolution plan. To provide this mechanism, this section 170A has been inserted, which specifically states that the corporate debtor can furnish modified returns within 6 months from the end of the month in which the order was issued. So it gives a time limit of 6 months from the end of the month in which the order was issued. Effectively, this section, introduction of this section 170A gives a legislative enactment to the decision of the Honorable Supreme Court in the case of Dalmia Power 420 ITR, wherein the Supreme Court held that the income tax department has to consider returns filed beyond the prescribed timelines under section 139 to give effect to the scheme of amalgamation sanctioned by NCLT. While this is a very welcome move, but it only takes care of part of the issue. Because say in case of a demerger, it is the resulting company which is the successor company. Section 170A that has been introduced enables the resulting company being the successor company to file modified return. But there is no enabling provision to enable the demerged company to also file a modified return, because post demerger both should ideally file a revised return. So the provision enables the resulting company to file, but not the demerged company to file. And while the provision has been made for filing the revised return, there is no provision under section 153 or section 144B of the Income Tax Act to enable Income Tax Department to pass an assessment order considering the modified return. While the government is yet to notify the form in which this revised return has to be filed, and once the form is notified, the intent of this section would be clarified to a larger extent, because we are yet to understand to what extent and what disclosure and for what period the returns would have to be filed, and whether all waivers, write-offs that has been part of the approved resolution plan would have to be reported. So it again becomes very important for all the resolution applicants to ensure that while filling up the form, they read between the lines and be careful about the potential impact of how the department is going to interpret those disclosures which are filed in this revised return under section 170A. Another interesting change that came in recently is introduction of subsection 2A to section 170-170, right, again by Finance Act 22 with effect from 1st of April. So this section actually seeks to clarify that assessment or other proceeding pending or completed on the predecessor in the event of a reorganization shall be deemed to have been made on the successor. So it actually is a deeming provision in order to save and validate the proceedings and to hold the assessment or other proceeding pending or completed on the predecessor in the event of a business reorganization to be held in the hands of the successor. And the object behind introduction of the subsection 2A is to provide immunity to the assessment made on the predecessor entities, because there were some judicial pronouncements wherein it was held that the assessment made on entities which ceases to exist are not valid. Honorable Supreme Court in the case of Maruti Suzuki 416 ITR has said that assessment order in the name of amalgamating company after the order has been passed is not valid. Now this judgment still holds good because subsection 2A relates to period prior to the approval of the business reorganization, that is prior to the final order passed by the adjudicating authority. While this subsection 2A was introduced with all good intentions, it has its ramifications also. So let me give you a small example. Assuming A Limited merges into B Limited, and during the period this amalgamation proceedings are going on, Income Tax Department completes the assessment in the hands of A Limited. Now, by virtue of section 170 subsection 2A, the order passed in the hands of A Limited would be deemed to have been an assessment made on B Limited. Now, once the amalgamation order is passed, B Limited would have to file a modified return under section 170 capital A, taking into account the result of the amalgamating company from the date of appointed date, and the assessment of B Limited pursuant to the revised return would be completed in the hands of B Limited. So effectively, B Limited will be having two demand notices, one under section 170 by 2A, which originally was in the hands of A Limited, and another pursuant to section 170A, which is in the hands of B Limited. Now, while this cannot be the intention of the legislature, and we are very hopeful that government will come up with due clarification at the right time, but this is actually a point to be noted that until and unless such clarification comes, this is a point of litigation. A very interesting interplay arises between section 178 and section 179 of the Income Tax Act. Now, section 178 talks about company in liquidation. Subsection 6 of section 178 was amended to provide the overriding powers of the IBC Act. However, there was no such amendment in section 179. Now, section 179 talks about liability of directors of a private company. So a view is possible that in case of a approved resolution plan where the income tax demand has been waived off in the hands of the corporate debtor and the conditions provided under section 179 are met, that is, the directors of the private company indulged in negligence, misfeasance, fraud, etc., Income Tax Department is free to move for recovery of taxes from the director of such private company, because section 179 is not overridden by IBC. While in spirit of the IBC statute, it is very clear that once the Income Tax Department demand is waived in the approved resolution plan, Income Tax Department should not have any recourse to section 179, as the same may tantamount to violation of the waterfall mechanism enshrined under the code. While time will tell the interplay of section 179 with the IBC, it is very important that necessary safeguards are kept in the resolution application, which is to be approved by the NCLT, especially where the corporate debtor is a MSME and the promoters are trying to get back their companies through the IBC. Another aspect of the Income Tax Act is the restructuring cost. As per the IBC code, restructuring cost includes the professional fees of the resolution of RP, cost of raising interim finance, and day-to-day running of the business. Now, prima facie, all these costs represents revenue expenditure and should be allowed as deduction. And even Calcutta High Court in Exxon Mobil has held that these restructuring expenses are revenue in nature and should be allowed. However, a clarification is still awaited from CBDT in this regard, and it is better that it comes on time to avoid unnecessary litigation on this issue. Many a times during the IBC proceeding, we see a change in shareholding of the corporate debtor. Now, what happens to the carry forward of loss in the hands of corporate debtor when there is a change in shareholding? While Section 79B, Section 79 Clause B has been amended, and after Finance Act 2019, it is 79/2/C, which provides that in case of change in shareholding of a corporate debtor pursuant to the IBC proceeding, the entire loss carry forward would be allowed to the corporate debtor. The interesting point is the language which is used under Section 79. What is said that the above relief, the benefit, would be available only after the jurisdictional principal commissioner or commissioner is afforded a reasonable opportunity of being heard. Now, practically how this will work out is yet to be seen, but I am still not aware of any case where the principal commissioner or commissioner has been called before the NCLT and given an opportunity to represent on this matter, because there are few questions which needs to be answered. Who will give them, the principal commissioner or the jurisdictional commissioner, an opportunity of being heard? And after affording the opportunity, whether a principal commissioner will pass a separate order or a direction, or the NCLT will be the appropriate authority to decide on the eligibility or otherwise of the IBC company to carry forward such tax loss. And whether the order of the NCLT or the principal commissioner will be binding and final, or again a writ petition can be filed before the High Court or Supreme Court. While only time will tell how this interplay will happen, because I'm yet to see a notice being issued to the principal commissioner, and I don't know, well, there are a lot of IPs in this call, they would be in a better position to update whether this is actually being implemented practically. Irrespective of whether it happens or not, in the interest of the corporate debtor and in the interest of the resolution applicant, it is very important that the resolution applicant and the IPs are specifically ensure that they approve that the resolution plan filed with the adjudicating authority is also forwarded to the jurisdictional principal commissioner or commissioner, so that they have the right and the option to come and represent. Whether they come and represent or not, it is up to them. But for us to ensure that we get the benefit of the carry forward of loss, the resolution plan filed with the adjudicating authority should be sent to the income tax department. A similar benefit has been provided under the MAT provision also, to allow the carry forward of loss to the corporate debtor. Generally, for a company, in case of a carry forward of loss, it is the lower of the unabsorbed depreciation of business loss which is allowed. However, 115 JB has been amended to provide that a company in insolvency can carry forward and absorb the aggregate of the unabsorbed depreciation and loss to be allowed. So there's a slight benefit here, where a company in case of insolvency can set off the entire unabsorbed depreciation and other loss, as compared to a situation where it is the lower of the two. While we discussed it, the case of change in shareholding, there is also a concern on what happens when a corporate debtor merges with the resolution applicant, whether the carry forward of loss would be allowed. Now, Section 72A does provide the benefit and says that in case of an amalgamation, if certain conditions are fulfilled, the losses in the hands of the amalgamating company shall be continued in the hands of the amalgamated company. However, the conditions which are required to be fulfilled are strange insofar as the IBC proceedings are concerned. I'll just give 3-4 of such conditions. The first condition is the amalgamating company must be owning an industrial undertaking. The surviving company must hold at least 75% of the book value of fixed assets of the amalgamating company for a minimum period of 5 years from the date of the amalgamation. The surviving company must continue the business of the amalgamating company for a period of minimum period of 5 years from the date of amalgamation. And the most strange condition that applies is the surviving company shall achieve the level of production of at least 50% of the installed capacity of the undertaking before the end of 4 years from the date of amalgamation. Now, in case of a normal business reorganization, while these conditions can still be fulfilled, but for a company under IBC, complying with the above condition could pose serious practical difficulties. And if the revival plan entails a merger, it may not be possible to comply with all the prescribed conditions for a variety of reasons, which may lead to a conflict and in all probability may defeat the objective of reviving the companies under IBC. We should also be aware here that under the Sikh Industrial Companies Act regime, the Board of Industrial and Financial Reconstruction, that is the BIFR as we all know, had the overriding power to provide that these conditions will not be required to be fulfilled in case of Sikh companies. But no such benefit or overriding powers has been given to the IBC. And therefore, to this extent, government should reconsider. And I would request the IPs here, as you people are also associated with many chambers and associations, to make this representation that this benefit which was earlier given to under SICA Act to BIFR should also be given under the IBC code. There are some other implications arising pursuant to the resolution plan, like there could be a scenario where the assets of the corporate debtor are transferred by way of a slump sale. Now, Section 50/2 of the Income Tax Act provides that the fair market value of capital assets sold on slump sale basis shall be deemed to be the slump sale consideration. Now, if the consideration of the slump sale is lower than the fair market value, there could be an implication in the hands of the transferor, which is the corporate debtor. Similarly, in case if there is a sale of immovable property of the corporate debtor at a price which is lower than the fair market value, subject to the safe harbor of say 10% or subject to the safe harbor of 10%. Now, here the implication will be in the hands of the seller as well as in the hands of the buyer, because in the hands of the seller, it will get attracted under Section 50C, and in the hands of buyer, it will come under the income from other sources 56/2/10. So if case the immovable property is transferred at a value which is lower than its fair market value, there's a double whammy. Another aspect of the resolution plan is transfer of equity shares of corporate debtor. Now, what happens generally is there are two ways this can happen. One is the resolution applicant acquires the shares of the existing promoter, or the shares of corporate debtor are issued to the lenders in lieu of the outstanding loans or interest. Now, this will have an impact under Section 56(2)(10), which is an anti-abuse provision. And in case if the shares are issued at a value which is say lower than the fair market value determined in lines with the rules prescribed under Section 56(2)(10), the same will have a tax impact in the hands of the person who is getting the shares. Another very litigated area is the taxability of the waiver of loan or interest. Now, it is an interesting area because there are interplay of three specific provisions of the Income Tax Act. One is the Section 28/4, which speaks about taxation of any benefit or perquisite, whether convertible into money or not, arising from any business or profession. And the second section is Section 41/1, which specifically says that if any loss or expense has been claimed as a deduction in any earlier year, and the same is either recovered or recouped in a subsequent year, the same would be taxable in the year in which it has been recovered or recouped. Now, Supreme Court in Mahindra and Mahindra has categorically said that as so far as waiver of loan is concerned, the same will not be taxed under Section 28/4, because loan is in the form of money, and Section 28/4 deals with some benefit which is not in the form of money but is convertible into money, that is, it is in kind. So since the grant of loan is in the form of money, Section 28/4 does not apply in case of waiver of loan. And in any case, since waiver in grant of loan is a balance sheet item and the same has never been claimed as a deduction, the same cannot be taxed under 41/1. So in so far as the waiver of loan is concerned, the Supreme Court is very categorical that the same should not be taxed. However, what is interesting to note is the wording used by the Supreme Court. What Supreme Court says in so far as waiver of loan and section 28(4) is concerned, that waiver of loan is nothing but money, and therefore 28(4) does not apply. Now, the moment Supreme Court said that it is money, section 56(2)(10) comes into play. Section 56(2)(10) says that if any person receives any money without consideration beyond rupees 50,000, the same would be taxed as income from other sources under 56(2)(10). So in case of a waiver of loan, if there is a shelter taken under 28(4) pursuant to the Supreme Court decision, it is very much possible that the department will come in the future and said, fine, this is money, and therefore this waiver of money has come to you without any consideration. So please offer it for tax under the income from other source under 56(2)(10). And in all probability, this should come as a litigation, and litigation on this point cannot be ruled out. Insofar as waiver of interest is concerned, insofar as interest on waiver is concerned, the same would be taxed under section 41(1) only if a deduction has been claimed in an earlier year. Now, for claiming of deduction in any year, we should keep in mind the provisions of section 43(B), because as per section 43(B), a deduction of interest is only available at the time of payment. So if the interest has not been actually paid but has only been outstanding in the books and the same has not been claimed as deduction, there is no question of taxability of such interest at the time of its waiver. Again, insofar as MAT is concerned, section 115(JB) is concerned, the waiver of loan should not have an impact because there are judicial precedents, including Mumbai Tribunal and JSW Steel, wherein they said the waiver of loan being capital in nature will not have an impact in section 115(JB). While in all cases under the code, as the resolution plan in majority case would involve right of waiver of huge sum, and accordingly tax implication will play a crucial role here. It is very important and necessary to find a way where specific assets that emerge out of resolution plan accepted by the committee of creditors do not result in undue tax hardships. Another section that is relevant to note here is section 281 of the Income Tax Act. We all know that in case where any demand is pending or any proceeding is pending by the income tax department, and during that period, if any asset is transferred beyond the stipulated amount, which is a very minuscule amount of 5,000-10,000 rupees, department has a recourse to the buyer of the asset. Now, in all probability, this does not meet the spirit of IBC, because once the resolution plan has been approved by the adjudicating authority, the demand of the income tax department is vacated. Therefore, section 281 of the Act, which enables income tax department to recover the outstanding tax dues, should not apply in case where the demand has been set aside by the IBC code. And the last, applicability of the GAR provisions on the transactions under CIRP. Well, we all know that in the Central Board of Direct Taxes issued a circular 7/2017, whereby they specifically provided that if the adjudicating authority or the court has explicitly and adequately considered the tax implications while sanctioning an arrangement, GAR should not apply. But however, in practice, most of the judgments, we know in practice NCLT does not analyze or consider tax implication while approving a resolution plan. And The income tax department is always given a leeway to proceed during the assessment proceeding once the resolution plan has been approved. Therefore, it becomes very important for the resolution applicants to ensure that the structure under which the resolution plan is being filed and approved and the corporate debtor is being acquired takes care of all these implications to ensure that post approval of the resolution plan and at the time of its implementation, they do not have to face unnecessary hardships. That's it from my side. Any questions?
Sandeep ji, if you could also kindly cover the tax impacts on sale during liquidation, whether TDS should be deducted or not, and what are the pitfalls and what are the things that maybe liquidators can be aware of and take care.
So, insofar as the applicability of TDS provisions is concerned, there is a view prevalent that TDS provision should not apply in case of assets under liquidation. And if I'm not wrong, there is a NCLT NCLAT judgment even on this point, which said that the TDS provision will not apply in case of IBC proceedings.
Om Prakash Agarwal. Yes.
Om Prakash Agarwal, right. So I think the NCLT in Om Prakash Agarwal said TDS provision shall apply, but NCLAT very clearly said that it should not apply. Yes. Any other point? Arunji, any other point?
No, I don't see any questions in the chat box also, but participants are free. Kindly unmute yourself and please address your questions.
I am myself surprised that nobody has any questions on income tax implications for the IBC code. I think Raj Kamalji wants to speak something. Arunji, can you please unmute him?
Yes.
Good to see you, Sandeep ji here.
Always a pleasure. Sarogi ji, कैसे हैं आप?
बहुत बढ़िया. अच्छा, my question, my opinion is that as you suggested that the jurisdictional commissioner needs to be responded on the concessions given by the to the corporate debtor. So in that case, while submitting to the NCLT the resolution plan for approval, at that moment of time, one of the parties may be that jurisdictional commissioner of the income tax. That will be solve the problem if they need to revert on that.
Yeah, I see. While the statute provides that he should be given an opportunity of being heard. Now, how that opportunity is to be given has not been laid down. So, to protect the interest of the resolution applicant, it is always advisable that all the resolution plan that the resolution applicant files, they should forward a copy. And they should request the principal commissioner or the jurisdictional commissioner to please represent and give and forward their views on it.
At the time of forwarding the copy, the commissioner may not respond, but if they are made to a party for their report, so in that case they need to report on that.
If that can be done, yes, Ravi, we should do it. Because tomorrow what will happen at the time of implementation, when you try to claim the benefit of carry forward of loss, income tax department will raise a caveat that we have not been given the opportunity of being heard, which is the stipulation under the law.
Normally the practice is not that it is being given to the commissioner. I request Sumitji also to respond on this point because he has got the vast experience on this matter.
No, I think I have also never done that. But what I feel is that instead of forwarding the copy of the resolution plan, which is a confidential document, because when you file it with the adjudicating authority, it is still not approved by the adjudicating authority. I think a letter to the income tax department stating that an application for approval of resolution plan for the revival of such and such corporate debtor has been filed, giving a reference to that section, and whether if they have any such, and you know, the RA can mention that how they have dealt with the income tax claims which were there in the you know, resolution process, and if they have any you know, submissions, they can come before the adjudicating authority at the time of the hearing. I think that should be the way forward, and that would,
in
yeah.
that case, the judicial commissioner may ask the copy of the resolution plan itself.
Obviously.
That we cannot give. That we cannot give, because it is very clear as per the law that resolution plan cannot be shared. In fact, even after approval of the resolution plan, I'll just share that many of the operational creditors have been asking me for a copy of the resolution plan, and they even marked a copy of the email to the Insolvency and Bankruptcy Board of India. So I categorically stated, informing the board, that no, resolution plan document cannot be shared because it is a confidential document, and the regulations, IP regulations, prohibits me to share any confidential document. So IBBI, you know, also took cognizance of the same, and you know, I was not required to submit the copy of the resolution plan. So that is the position of the law as it stands today. So I mean, income tax creditor for me is just another operational creditor. So
But
I would
Sumitji, see, the requirement under section 79 is not in respect of the income tax demand. It is in respect of the carry forward of the loss of the corporate debtor in case of change in shareholding. So
Correct.
where a resolution plan is being furnished, whereby the shares of the corporate debtor is being acquired, in the interest of the resolution applicant to enable it to carry forward that loss and adjust it in subsequent year, at least that relevant aspect of the resolution plan should be forwarded to the income tax department, so that tomorrow it is not disputed.
Absolutely. That is why I said the extract and the application for approval of resolution plan under section 31 of IBC should mention in the pleadings that a copy has been sent. In fact, sorry, that is being forwarded by RP, but normally the RA also gets tagged when the application is being heard. So in their affidavit, I think that can be, you know, inserted as a pleading. So that will help the RA.
And the acknowledged copy should be attached along with the application.
Absolutely.
So in that case, the RP cannot make the judicial commissioner a party to the application for the NCLT.
हाँ, पार्टी नहीं बनाना है सर, वो तो उनको उनका ऑब्जेक्शंस, अगर पार्टी बनाने का तो लॉ में लिखा हुआ नहीं है ना संदीप. I don't think.
The law simply says that you have to give an opportunity of being heard. That's it. After affording a reasonable opportunity of being heard to the jurisdictional principal commissioner or commissioner. That's the
So
law.
opportunity of being heard can only be given by the adjudicating authority. I mean, the RP or the RA cannot give an opportunity of being heard to the income tax.
No, in fact, we should make a specific prayer to the NCLT, to the adjudicating authority, that please give the opportunity of being heard and please inform the income tax department.
Correct. That is a fair suggestion.
Then a notice will go and multiple notices will go.
Because the carry forward benefit is also huge for the RA. So
Arunji, it is always better to take the pain beforehand rather than lose everything post approval.
I agree, that's true.
No, I think it was a very interesting session. More such sessions are required, because there are a lot of implications, and now we have seen so many resolution plan getting approved, and you know, thereafter income tax department is also, you know, awaking slowly and steadily. And they are also realizing that there is something called insolvency and bankruptcy code.
They're losing lakhs of crores of rupees. So now obviously all the government departments are realizing and awakening.
Absolutely. So this is very vital whenever for any resolution applicant, when they are putting in a resolution plan. Instead of seeking waivers and concessions, I think these important aspects should be kept in mind while drafting the resolution plan.
Absolutely.
So if there are no more questions, then I'll ask CA Neeraj Harodia ji to kindly propose a vote of thanks and present the e-memento to the speaker.
Thank you.
Thank you.
So thank you very much, Arun Bhaiya, Chairman, IBC committee of our association. First of all, I am very much thankful to CA Sandeep Khemka ji, who has taken out time and did a detailed discussion on the implication of direct tax in the law related to CIRP and the liquidation process. In fact, whatever he has discussed, the practical issues, the practical problems what everyone is facing today. So in fact, Sumit Bhaiya, if you remember, we had a detailed discussion on some matter related to indirect taxes as well. There
Correct.
also we are facing lot of issues practically with the GST portals and how the GST department is reverting post this entire takeover by new management. So I
Correct.
think after listening to this session, I think we must organize a session especially for indirect taxes as well.
Correct.
That also is need of the hour, and we must have some practical solutions.
Yesterday
So
we had a small session on indirect tax, same thing.
same
Yes.
thing.
Yeah, that was only for half an hour. I think after hearing Harsh, I felt that, another half an hour was also required so that other aspect could also have been covered. But
Correct.
yes, what you're saying is absolutely correct.
Yeah. So, Sandeep Khemka ji, we are very much thankful. So, because since this seminar is online, so we are offering you e-memento, and this is the beauty of. I think this is visible now, Arun Bhaiya?
Yes, absolutely.
Yeah. Okay. So this is the e-memento on behalf of our association, and we will look forward for your time in future as well.
Thank you so much. Thank you so much, Neeraj.
And this we will email you. This we will email you for your record.
Thank you
And
so much.
we are very much thankful to all our participants who have who have taken out the time and attended this seminar. And we request all of them to become those who are not member of our association to visit our website. They can contact us also to become members. So we regularly contributing. We are arranging these kind of seminars. We are coming out with our association journal. So definitely, by sharing the knowledge with each one of you, definitely knowledge of each one will increase. So thank you very much.
And also the link, Neeraj, you can say when the link will be uploaded so that anybody wants to see the recording and they can
Yeah.
just.
So this is their live telecast is today recording in a private way, and we will made it public by tonight on.
Thank you.
Thank you very much.
Thank you very much. We can close the session now.
Yeah.
Thank you.
Thank you, everybody. Thank you.
Thank
And have a
you.
good weekend. Bye.
Thank you.